ওটাই করবে, আমি আগে করবো।
করো, তুমি করো।
Leave may be granted to file this appeal, memo of appeal without certificate copy. 16 October, September, the order has passed. We have already applied for certificate copy.
Thank you. Yes. Lordship, leave granted, Lordship. 59, Lordship. The order has been first at 79.
Yes.
Lord, the item number 44. Lord, that matter, my lord, physical education, my lord, the
একটাতেই তো দিব।
almost, my lord, the hearing was concluded.
Yes.
My lord, the
What
kindly
can we do, Mr. Jana?
tomorrow, my lord, the kindly before the
We have kept all those matters on 4th. I think it cannot be reached. So if you are desirous, we can keep it on 4th, or if it is reached, we shall. Choice is yours.
tomorrow it is not possible, my lord. The only, my lord, the I have produced the staff pattern, my lord. The hearing was almost.
তো ওই ম্যাটারে এই ফরওয়ার্ডার্সটাকে একটু উপরে করে দাও। এই আইটেম
কবে 4 তারিখ?
forward, we have fixed similar matters on that date because we heard you on 4th November. It will appear on 4th
No,
November.
my lord, if it is reached, my lord, let it remain. If it is not reached, then 4.
No, that way we cannot assure that. Then you won't be there, we will be there. Who is your other side?
My lord, the Supriya Chattopadhyay.
So tell him, item number 44,
44.
না? 44 টাকে একটা ওই দিনকে দিয়ে দিয়ে। Yes.
My lord, item number 55, my lord. It's an assigned matter, my lord, with regard to that daughter, unmarried daughter who is to get the freedom fighters pension, my lord. I am mentioning if it can be fixed at any day, my lord. The other side, Mr. Learned AG, is to submit and the matter will conclude. We have concluded our arguments, my lord. I am playing any day if my lord fixes it at any time. It's running in the list. 79 years of age, my lord.
My lord, I beg to mention, my lord,
No, where is your other side?
My lord, he is not here. So I'll inform him. If my lord fixes a date, then I'll.
No, in their presence, various problems are created. You bring the other side advocate on record, we will consider.
My lord, I am praying if my lord fixes a time, I will give the notice to
In
the.
his
My lord,
presence.
very well. My lord,
No,
tomorrow.
then it will, because we are not allowing in those matters. Kindly inform your other, come with your other side, then we can.
Tomorrow I will give notice and I will tomorrow come.
No, you have to bring, otherwise.
My lord,
Yes,
my lord, I beg to mention, my lord, two matters, my lord. These matters, my lord, similar matters are fixed on 4th of November, my lord. My lord, I am mentioning for enlistment with these matters, those matters.
similar matters.
Similar, my lord,
Break up from the slumber and come similar matter. What is the matter about?
my lord, the matter is, my lord,
Physical education or
education matters, my lord. The
education
transfer,
matter we know, but which matter? Is it physical education or other?
my lord, transfer application, my lord. Those are rejected, my lord. On the similar matters, my lord, these are
When did
Priyanka Sorkar is, my lord, the main.
yes. No. Further addition cannot.
No, my lord. These matter is only in the list of, my lord, August, my lord, monthly list of August. But I am praying for the inclusion and enlisted, my lord, on 4th of November, my
Remind
lord.
us on that date. Hearing has not concluded. Remind us on that. Yes, call the list.
May I, my lords, kindly to mention, my lord, a matter, my lord, an appeal, an education appeal, my lord. The matter was released, my lord, the day before yesterday by Division Bench of Justice Shuja Paul, my lord, with the direction that the matter be listed before your lordship.
Hearing or motion?
My lord, hearing appeal, my lord.
What matter? A pay scale?
No, my lord, it's about a school service commission recommendation, my lord, upon the Ramakrishna mission, my lord. And the recommendation, my lord, the recommendee, my lord, only a brief overview. The recommendee, the person who has been recommended, my lord, has been acting in breach of the undertaking, my lord, pursuant to which, my lord, the writ petition has been disposed of, my lord.
It becomes a contempt, Mr. Sen.
No, but
Undertaking breach.
Yes, my lord, we have other grounds of appeal as well, my lord. Kindly gives me an opportunity, my lord, to move the appeal.
Sir, where is your notice? It is not in the list.
My lord, the day before, yes, my lord, the day before, yes.
It after vacation.
My lord, there is some urgency. I'm only seeking, my lord. My lord, the direction is for it to appear on Thursday, my lord. It is, my lord, should appear, my lord, on Thursday.
That may have been the direction of Justice Paul.
Yes, my lord. Yes,
but we are the masters of our.
I bow down. I'm only seeking, my lord, if any day before the vacation, my lord.
Assigned হয়ে এসছে? Has it been assigned?
Direction being given, my lord, for it to be listed before the appropriate bench on Thursday, my lord.
The number দেখে নাও তো।
Yes, my lord.
Where is your notice to
My
the
lord, this is the notice, my lord. Unfortunately, my lord, I'm not.
ফাইলটা? ফাইলটা
Deeply obliged, my lord.
কিছু বলবে?
I beg to appear for the appellant. This was mentioned at my instance.
Lord, I beg to appear for the private respondents, Lord, in this matter. Am I audible to your lordship, Lord?
Yes.
I beg to appear for the state respondent, sir.
But I was appealing for the KMC, respondent KMC.
Yes.
But I'm seeking to file paper books in respect of the matter. This is a hearing matter. Informal paper books were prepared in advance. There was no direction, formal direction on the last occasion. I just beseeched your lordship to kindly pass directions for me to file the paper books. Then hearing can be fixed at any point after the vacation.
Picked up the defect. What is the defect? The present appeal has been preferred. Had it been with notice, Mr. Oh, you are there.
I'm for the state, your
That is
lord.
all concerned
The
parties are
answering
there.
respondent is the KMC.
Appeal, the present appeal has
Yeah, I just saw. All I give me
please complete service so that we can take it up on that.
So my lord has kept it returnable, my lord, on the monthly list of November. But I could not, my lord,
18th of November.
18th. I'm obliged, Lord. I'm obliged.
Yes, next matter. Same matter. Same.
No, my lord, this is not.
পেপার বুক গুলো দেবেন না পেপার বুক গুলো
No, I'm for the appeal. Sorry. সেইগুলো সব জানতে চেয়েছি। ঠিক আছে। এটা তুমি ইচ্ছাপুরটাই নেই সেটা বলে
After
My lord,
the
on the
order
same
has been
date, my
passed,
lord.
After the order has been passed by your lordship, on 20th, the petitioner appellant was asked by the chairman. But he appeared before the commission itself. But out of 21 vacancies, available vacancies, there are no applications were pending. But 3 options has been given to me. But kindly see this, copy the
My lord, chairman is trying to resolve the issue by
Kindly
giving
read.
certain options. My lord, see, my lord opted 3 schools. My lord, thereafter, my lord, school service commission, my lord, send my lord mails to those schools. Is there any complications or my lord the pupil teacher ratio? And is there any litigation? Status of those vacancies. After my lord getting response from the concerned school authority, my lord, school service commission will issue necessary recommendation for transfer.
Now,
In any of the 3 schools.
now,
If at all vacancies are available and subject to pupil teacher ratio, my lord.
No, no, vacancies are available, that is.
My lord,
that is why it has been given to us. Now, what happened? My client, during this period, went to the one of the schools personally, talked to the teachers concerned. In first choice school, as given by the chairman, no vacancy at all, even then.
even if it is in the
there
portal,
are-
it shows that it is vacant.
Now,
Because
kindly see
portal
the
is-
predicament of the teacher.
Portal is maintained by the government.
Searching did you choose?
But,
Which school did you choose?
Out of 3, she contacted with the 3 of the schools.
Aha.
Now, 2 options are available out of these 3. In one of the schools, Dom Adarsho Ashram, if your lordship takes that name of the schools, when I am giving this up-to-date data.
এটাই দিয়ে দিচ্ছি।
What is that is given here? Tell us now.
Yes, now, in Dom Adarsho school, there are students 2,000. Teacher existing 60. There are 2 teacher in Bengali.
Local arrangement has been made. Somebody will come to your place.
In that case, where I am working.
That
Now
has
it
been
is-
confirmed.
Yes, that is there. Now,
Now then, what is your problem, Mr. Viswas?
not my problem.
You want further options for further vacancies.
No. Now, let me clarify. That vacancies where I have to join
Hmm.
new school, transferred post. 3 options has been given by the chairman. And out of 3, in Ichapur case, which is nearest to my school,
There is no vacancy.
there is no vacancy
Understood.
existing. So I cannot join there.
Very well.
Now, second option, Dom Adarsho. There are 2 already Bengali teachers are there. But in a third school, Birati High School, there is no teacher of Bengali. I can be accommodated in that school, even since there is no Bengali teacher in particular subject, I am not teaching. So out of those, Dom and Birati, either of the 2 I can be, but in Birati, it is suitable for because that no teacher of Bengali subject is there.
My lord,
So
kindly,
this is the latest position.
my lord, kindly adjourn the matter, my lord.
They have already said that they will give to you.
My lord.
Furnish that information.
Oh, yes,
My lord,
I
we
have-
have already, according to her choice, my lord, we have school service commission has already intimated the school authority.
No, he exercised choice for Ichapur.
Yes, my lord.
Ichapur is not available, he said.
According to him, my lord, we have not received any information from
Mail
the
has
school.
been sent already.
We have forwarded a mail to Ichapu school, Dom Adarsho Ashram, and Birati High School. 3 schools we have sent mails. My lord, after getting satisfactory answer from the schools, my lord, we shall issue recommendation
But
later.
Mr. Rai, see that in the meantime, if at all there is any vacancies, the same is not forwarded or filled up by the commission otherwise.
No, my lord.
Otherwise, his right will go.
My lord, ultimately commission will issue recommendation later, my lord. My lord, if my lord, this is Ichapur school.
Are we required to pass any order? Or
No, my lord, simply, my lord, by passing an order, kindly adjourn the matter. In the meantime, school service commission will resolve the issue, my lord.
Secretary order করা। Since you have given the option,
When were you called for counseling?
My lord, on 20th, my lord, she attended.
Yes, notice has been given, notice has been.
20th September.
So commissioner, chairman has given these three options. I have chosen. Out of that one gone.
We understand.
Then, my lord, if Birati is suitable because of the fact, although this third option, there is no existing subject teacher. So I can be easily available to be accommodated. So kindly pass to that extent, my lord, order, because I have,
No, my lord, it is not, my lord.
otherwise কি করে হবে?
Commission is, it
All
is
right, I leave it.
commission. How she can choose, my lord? It is under the prerogative of the commission, my lord. How, Lanet,
No, no, Mr. Rai, we shall record that after this order was passed, he was called for counseling and offered
yes, my lord.
appointment, offered to be transferred to any of the three schools. We will record his submission that, we will record your submission that you have already sent communication to this teacher to understand the vacancy position.
Yes, my lord.
And we will record that to him the first school. That will create confusion for you, Mr. Vishwas.
Sir, already school has sent yesterday. This is the
No, we
given
have
update
not
by the
received
school
any
authority.
official.
That is your choice, Mr. Vishwas. If you want us to record that, see that no right
ছেড়ে দাও
of
না।
yours is
তিনটের মধ্যে একটা
I leave it to lordship and good office of the chairman. I cannot.
my lord, I am trying my level best.
Because I am to join elsewhere of the three schools. Otherwise, if each are given,
Unless an
no vacancy,
official communication
recommendation I
There
get.
must be an official communication from
from the school authority.
Service Commission.
So prior to calling him, then you could have taken the vacancy.
My lord, we have, my lord, showed her, my lord, 21 vacancies. From those 21 vacancies,
Oh.
she opted 3 schools.
Achha.
This is those 3 schools which
And-
are nearer to her
It
residence.
should have been checked up, na, tomorrow office.
My lord, now
Lekho, Mr. Vishwas learned
board, misdemeanor.
Oh, also. Then do we keep it a bit later? Because it will be sent to the board. Board will also have.
Let it be. My lord, transfer recommendation will be issued by the School Service Commission.
Then it is,
Thereafter, my lord, the School Service Commission will forward the transfer recommendation to the board for issuance of transfer order.
item number.
Appealing for the state response.
Item number 3, my lord, I am for the.
My lord, I am for the response number 6 to 11. My lord, on the last occasion. My lord, on the last occasion, I placed on record the order of the Honorable Supreme Court. After this order, nothing survives. On the last occasion, since my learnment was not, the lordships kept this matter for passing order to.
Hearing informs us that the special leave petition has been disposed of setting as a Mr. Kopi.
My lord.
My lord, in 2003, the victim girl got missing from her house. Thereafter, a complaint was lodged. This respondent was 6 to 11. They have been arraigned and accused. They were arraigned and accused. They faced, my lord, the investigation, everything. They took out an application for discharge. That discharge application was allowed by the learned trial court. Against that, a revisional application was preferred. Now, in 2023, a habeas corpus writ application was also preferred. My Lord Justice Devanshu Bosher was the principal judge in the other bench, coordinate bench, was pleased to hear out both the matters together and
Habeas corpus
and both the revisional applications together.
Revisional application.
Yes, my lord.
But
Thereafter,
how can the revision application be heard by the division bench?
no, my lord. Since the habeas corpus was pending there, my lord was pleased to call for the record of the revision application and stacked both the matter.
Then set aside the order of.
Then
discharge.
set aside that order of discharge and directed the learned trial court to consider it afresh. And so for the habeas corpus,
Consider what afresh?
my lord, the discharge application again.
Oh, I see.
Thereafter, my lord, so far the habeas corpus writ application was concerned, my lord, since the further investigation was pending, my lord was pleased to keep this pending also. Now, my lord, against that order, the accused persons, they moved the Honorable Supreme Court. The Honorable Supreme Court was pleased to set aside the entire thing. My lord even restored the trial court order, that is the order granting discharge to the accused person.
And what did the court say about the pending habeas corpus?
Everything has been disposed of because, my lord, kindly says I have handed or placed on record the order of the Honorable Supreme Court. My lord, kindly says paragraph number 6, 7, 7, 8. Submission of the state was recorded.
No, but this is an order passed on the revision discharge.
No, my lord, against the order, my lord, there is a reflection of the order of this Honorable High Court in at paragraph page paragraph 5.
Read the second paragraph, Mr. Jana.
The paragraph 5.
Paragraph 2.
Paragraph 4.
2. Para 2.
Paragraph 2. My lord, we have challenged. That is the recording I find. But my lord, since the order was a joint order, absolutely a joint order,
What
because
do you say?
Lord, there are several
The girl is still
she is still missing, and Milord will take the reports. 2 reports have been filed before your lordships during the pendency of this habeas corpus.
She is a minor.
She is not right now. She is not a minor, but at the time she was lost, she was a minor.
When was she lost?
2003, Milord. Since 22 years, the girl is missing.
2003.
Milord. Milord, in 20, Milord kindly takes the.
No, wait. Now the criminal that discharge has been confirmed. So, is there any other accused?
Lordship, may I humbly submit that on 21st August 2024, a fresh record was placed before the coordinate bench showing that there was in the media, there were certain reflection that some person stated that we knew about this particular girl. Accordingly, the honorable coordinate bench was pleased to direct us to continue with the investigation. Now we continued with the investigation and we have filed a report before your lordship, whereby we have examined those persons who were shown in the video. Now they have negated the entire thing. They say we know nothing about this entire matter.
Then have you
No, we are
submitted
in a,
charge sheet?
no, we are in a position to file the
For
final.
20 years, no charge sheet.
No, my lord. What happened in
No,
2000?
charge sheet was filed.
That
is why we got discharged.
Disappeared from the records.
Oh, acha, acha.
That is
It
other.
conveniently, it has disappeared from the records. It is not in the records of the Juvenile Justice Board. It is not in the record of the original, the
But sir,
additional
how long
judicial
can
magistrate.
we needed continuation of the investigation?
You know, kindly takes the report filed by,
To give us some particulars that maybe she is there.
my lord, kindly,
Unnecessarily, we will not keep it pending.
My lord.
She's an adult lady.
My lord.
20 years gone by. When did you file the habeas corpus?
After 20 years.
Milord, 2020. Milord, I knew, Milord, that this question might have come. Milord, in 2003, my daughter, Milord, in 2003, Milord, my daughter went missing. I went before the police station. I filed a
How
complaint.
can we help you, sir?
Milord, kindly take, Milord, the report filed by the CID on 7th August 2025 before your lordships only. And Milord, that might be read conjointly with the
Acha,
order.
let us first show that
Milord.
paragraph, then we will conjointly.
Milord, I apologize.
Yes, which paragraph?
Yes.
So
Milord,
what,
the report
Mr.
dated.
Govind, you are doing? 20 years, you cannot find out a guard.
Lordship, may I humbly submit one thing, that the report that we filed, because they came up before this honorable court at a very belated stage. Now, there was only a missing diary initially, and subsequently an FIR was lodged, and on the basis of that, charge sheet was filed because there were allegations against those particular persons.
Now they have been discharged.
They have been discharged only except the juvenile.
Milord, we have also prepared a
Only
review
except the
application.
juvenile who
The husband.
the husband. There was a marriage between two minors. This missing lady at that time was also a minor.
Milord, kindly.
My lord, both were minor. The family members of the husband
So
did not
what
accept
do
the
we do?
marriage.
Tell us, is there any probability?
No, my lord, we are at a
CID has
position
made
right at
for
this
polygraph
moment to
test.
file the final report before the concerned court, because if your lordship kindly takes my report once, the last report on 8th September, where on the basis of which
That is, my lord, not has been served upon me. I have the report dated
Wait,
7th
sir,
August.
please don't interrupt. When was the discharge petition filed?
lordship, the discharge petition was filed.
That was in the year 2023.
2006, the charge sheet was filed.
Give me the original application. My lord, the discharge was filed in the year 2023, 2nd February. That is an annexure in the revisional application filed by my learned friends.
Lordship, the charge sheet was filed in the year 2006.
It is where is the revisional application?
They had an allegation that there was a recovery of the skeleton, that there was an allegation
That was not my allegation.
that might be that skeleton might be of that particular lady, and that accordingly a video surfaced in the media stating, some person stated that was that particular lady, and that came after 20 years, and that was placed before the coordinate bench. On the basis of that, our investigation was directed to us, and we examined those persons who featured in the video. Now they negated everything. Well, we don't know anything about this. And there is an allegation.
Has that been reflected in the charge sheet?
No, my lord. At that particular time, this video
When was the charge sheet filed?
in 2006, my lord.
My lord, victim went missing from the custody of mother.
Habeas corpus, we cannot help you.
Kindly, my lord, hears it out, and thereafter, whatever first.
Come prepared, we have to. We are not inclined.
I am prepared, my lord. My lord, may I place, my lord, few paragraphs from their report only.
Come after mediation.
One indulgence. There was also an allegation against this particular complainant by those witnesses itself, that she stated that she will pay 60,000 if this video is being given in the.
Mr. Gopi, on the next day you make a short list. You
My lord.
give us the list of dates as to what happened on what dates. You also
My
come,
lord.
we will
I
consider
will.
it. Mr. Jana.
My lord, only predicament I am facing is, my lord, since the Honorable Supreme Court was pleased to set aside the entire order date 30th August
No,
2024.
not the entire order.
My lord, the kindly comes to paragraph 9.
That is
That is-
again creates a confusion. Then you should have included the habeas corpus also. Habeas corpus, you could not have gone to the Supreme Court.
My lord, against this order, so I went to
If it
Supreme
is
Court.
pertaining, an order may be passed in 5 matters also. So
Well, paragraph 2 and paragraph 9, that is.
your appeal was restricted to the order pertaining to your discharge application.
My lord, since the order is passed, both the matters were
What do
tagged
you want?
together.
You will dismiss the habeas corpus. You're wanting that.
My lord, I do not want. Only thing is that, my lord, my discharge, since the matter is again pending before the London trial court, my lord, I have been discharged. May I just bring on record this order there, because pendency of this application here,
Which order there?
this honorable Supreme Court's order.
Yes, we have not
No,
prevented.
but my lord, because of the pendency of this application,
Habeas corpus.
but this application is also tagged together with the habeas corpus.
Mr. Jana, you know what steps are to be taken. Then do we pass any order or we keep it on the next returnable date and come and tell us?
Lordship, we will come with an complete
I'll also, my lord,
list
file
of
my
dates.
Mr. Jana, learned advocate. Give if you have prepared handover that note of argument what you are
My lord, no, notes of arguments right now I do not have. I'll prepare, my lord.
Yes, next. Item 6. Who is there?
I am on behalf of the petitioner.
My lord, I am for the private respondent. Affidavit of opposition.
Opposition.
My
Ah.
lord,
What is this matter? Habeas corpus.
habeas corpus, my lord.
You have given the reply.
My lord, today, right now, I have been served with the opposition, my lord.
Huh?
My lord,
Acha, Lekho, Miss Naz.
Yes, my lord.
And the advocate appearing for the respondent number
I'm appealing on behalf of the opposite party husband. The last August in your lordship.
Your husband.
I'm for the petition, my lord.
In this matter,
No,
Mr.
what
Sudipta
a
Panda is
man.
having for the
That
petition,
man-
state, my lord. He is on leg before court room number 35.
Uh-huh.
Mr. Sudipta Panda applying for the state, my lord.
Very good. You are there now. কি হলো সমস্যা? Any result?
No, my lord. The situation is that the wife is that they are not to go to the place of the
Yes,
husband. He
refused to
is
come,
very
my
much frightened.
He'll-
And my lord, last August, my lordship directed him.
Mr. Beda, you tried your best. What more can you? What more can you do?
Only the point is that last point that in the place of the husband, my lord, there is no one is there. Only the husband, wife, and the child was there. And after my lord, she has left, my lord, there is no one to take care of the child. my lord. No one to take care of the child, my lord. And
Place
because
your
both
case
the
in-
parents has died.
Place your case.
Yes.
Come to the writ petition.
Lordship. And the child was a IVF child. IVF card is annexed there.
We are with you since the age is 11 months. We are with you.
Yes.
But the thing is, she now wants that I will not go to the matrimonial house. You hand over custody to me. There are disputed facts in between you, allegations counted. We can at best say that we will give visitation right to you, and you make a formal application for guardianship.
My lord, in that case, my lord, I have placed before lordship one judgment by Supreme Court where to, my lord, curtail down the multiplicity of cases and also shorten the time, my lord.
How?
My lord, Supreme Court has directed, my lord, copy should be there, my lord. I have given where, my lord, in a very short period of time, the dispute was resolved. My lord,
What did
1981, 3 Supreme Court cases, my lord, page 92. Where, my lord, Supreme Court, and paragraph 3, my lord. Called for a report from the district judge.
You're showing? What you are saying?
At paragraph 3 of that judgment, my lord, my lord, it is difficult for us in this habeas corpus petition to take evidence without which the question as to what is in the interest of the child cannot satisfactorily be determined. We therefore direct that Ladner District Judge Chandigarh will make a report to us before the 23rd of this month on the question as to whether the custody of the child should be handed over to the petitioner mother, taking into consideration the interest of the minor. The learned judge will have liberty to the parties to adduce evidence on the question in issue. The learned district judge may either take up the matter himself. Similar to
Yes,
curtail down
that petition you filed.
no,
the guardianship.
no, my lord. In this case, my lord, High Court directed to give a report to the my lord.
Because how can we direct the district judge to file a report, take evidence? It must be on the basis of some material before the district judge.
Yes,
you
my lord.
file an application under Act 8. Till such time is we will say that our you are not willing to go. What can we do?
That is the problem. I have talked with because she is in
She
the
doesn't
trauma, my lord. In a trauma condition. Because the relation of the attitude of the husband, my lord.
No, my client is very cooperative and he had talked with her and she
Now she is
refused to come.
residing along with
father and mother.
father,
in Calcutta.
and you don't have parents.
No, I have the parents. My client have the parents.
Then,
Both
sir,
have died.
how you are
And my client on the last occasion, my lord, we have talked to the petitioner and she assured that he will come after puja. And at present,
I don't.
So during the entire puja, 11 months child.
Yes, my lord. She is refused to come, my lord. I am no objection if she will come and
Don't
stay
know
with
what he is saying.
husbands and the child. And on the last occasion, I submitted.
Then who looks after the child?
That is the question, my lord.
There must be somebody else to look after the child.
It's
You must have kept a maid servant.
maid servant and his sister is there, my lord. Citizen sister is there. Sister. As per my instruction.
Leaving the mother, sister, that is auntie.
And on the last
Asansol. It is Asansol.
Cheliama, Raghunathpur, Purulia. And I have no objection. If she comes,
Then you go with the child. Meet with her. You go. 1.5 years child, sir.
If she will come, and she assured that she will come, my lord.
No, one thing is that you are a working person.
No, businessman.
Business.
Yes.
What business?
Promoting. I have
no promoting.
Who looks after the child must be kept with a maid servant.
No, maid servant. His relatives is there, my lord. His relatives and sisters is there, and a petitioner submitted the statement, notary agreement. On the last occasion, I have submitted, my lord.
Notary agreement for what?
Yes, sir.
That is before the dispute arises and
no. And she admitted that she put her
Is there any 498 case?
No dispute. I, Sutopa Dotto, wife of.
Where you are DD?
On the last occasion, my lord.
China.
I am the legally married wife of Sombhunath De, and that due to the said wedlock, I have been blessed with a son, namely, and my husband.
Just আমাদের দিকে ঠিক হয়ে গিয়েছে সাথে আমার মা শ্বশুর দিয়ে বাবা ছিলেন চলে গেছে ছোট বাচ্চা ছিল executed when? 13th of March.
Yes.
13th of March.
Yes, my lord. And she admits that she put her signature. Sutuba Dotto.
Now I put
That my husband has been maintaining
in the
me
normal
and my
relation,
minor property.
question of affidavit
They will.
comes, my lord. If there is no any, but I put to myself the question, my lord, in a normal relation, how this kind of affidavit will come, my lord?
She is enjoying the audience in High Court.
No, my lord, it is a
She
before
doesn't
that
want to
problem
beat
arrives.
up the problem. She says, I have given to the High Court, now High Court will send it. You are so staunch. You are not, you have also tried your best, but you couldn't
That is true,
convince
but
her.
she is traumatized.
My lord,
That's-
there is a
my lord,
police
last
report.
occasion
If
when
she is traumatized, how is she is meeting you and saying that I will
Yes.
not go give over
not
the
going to Raghunathpur, she is traumatized.
He is in
to go
normal.
back.
we are saying we will give you adequate protection.
Yes.
And if
I have
we
told that.
find that after that, if she goes
Yes.
and she is not allowed, we'll keep the matter pending. You will come and tell us.
Yes.
Then we can determine. Otherwise,
I just not come today.
lady, you work somewhere or working lady.
No, no, no.
Who are there in your place, your parents are there.
Yes.
Where do you decide?
At Khizirpur, my lord. Every day she was coming. Today she is expected to come at Khizirpur.
Right.
In that case, my lord, if a report can be called for from the district court, my lord, upon visiting, upon
That for that you have to file the Guard Act 8 application.
my lord,
We will record that.
in this case, what happened, my lord? If
This
you,
will not cannot be done. Please don't request that.
Lord,
That is 142 jurisdiction. Don't request.
Lord,
এগ্রিমেন্ট হয়েছিল হাজবেন্ডটা কই বলছে এগ্রিমেন্ট হয়েছে এগ্রিমেন্ট কই এগ্রিমেন্ট আগের দিন রসটাকে দেখছি আমি কপি করে কিন্তু তুমি তো দেখবে না এটা দেখেই যাচ্ছে বলেছিলেন দেখে
চাইছি হচ্ছে
Lord, I put the petition, my lord. And for the respondent number 9, Lord, I took, Lord, the endeavor to bring back the child, Lord, in the Pratt Memorial. But it could not happen because of the reason the maternal uncle went and made the principal. My instruction is that he wanted to withdraw the child, and that's the reason he insisted, Lord, for Lord TC certificate. So, Lord, he has not taken the child to the Pratt Memorial. Only for the purpose of visitation, they went. And I need to file a supplementary affidavit annexing, Lord, the action and the correspondence made, Lord, by us.
So where is the child now?
Child is with the maternal uncle. Lord, it is that matter, Lord, where the maternal uncle has.
Sir,
And your
where is Mr. Sen?
is before the courtroom number 29. I'm praying
So
for
you
short
have not
pass.
asked that what steps he has taken.
I'm praying for short passover. I need to file a supplementary affidavit, Lord, annexing, Lord, certain
Mr. Ahmed Learned admitted appearing for please for leave to file a supplement. Yes, 9.
Lordship, I'm appearing on behalf of the petitioner.
Yes, petitioner.
Yes, Your Lordship. My Lord, I'm for the private respondent, number 11. The last occasion had directed me to file supplementary affidavit, bringing in record the Guardians and Wards Act application along with the interim application that was preferred before
What
the Lord.
happened? When is the next date fixed?
Lordship, 10th of February 2026.
What order you are wanting from us now?
Lordship, only seeking visitation rights, Your Lordship.
All the matters that he has filed.
Visitation right application you have made to the court, no?
Yes, Your Lordship, we have preferred, but Lordship kindly sees the date, Your Lordship. It's been 2 years that we have not
So
seen.
why haven't you filed a preponement application before the court?
Lordship, but that is the discretionary power of the court, Your Lordship, whether it might.
It has to be the decision on your part, whether you will go for preponement or not.
Yes, Your Lordship, but
So
Lordship.
file an application of preponement. In
Lordship.
that preponement application, say that habeas corpus is pending. You hear the matter immediately.
Lordship,
You did not do so. We heard the matter last on 10th of September.
Yes, Your Lordship.
Then did you go and file any? We told you on that date also.
Lordship, we had preferred the application prior on 10th, Your Lordship. Like we have preferred the application
Then
with the.
you are Mr. Sen.
Yes,
Then
Your Lordship.
Mr. Sen, you should have made an application for preponement. What you are this father?
Yes, Your Lordship.
My lord, on the last occasion, my lordship had, yes, my lordship had asked me to seek instruction. My lord, I've sought instruction from my client. My client has no objection if they seek to visit the child, but it should be at some location which is close to our home because he's a
Lordship,
resident
may
of
I-
Murshidabad
may I
and I am a
suggest one-
resident of Memari police station, my lord.
No,
So
where is the child now?
the child is staying with me right now.
So he will go to your
He
place.
may come, my lord. I have asked my client, but it should be at a neutral location because, my lord, there is
Again, neutral, how many years old child?
it
2 years,
2 years old.
কোথায়
I
নিয়ে
tell
যাবে?
your lordships why, because my lord, there's a lot of bad blood between the parties, my lord. Some untoward incident may happen, which is why I am saying, my lord, the visitation, I have no objection to it, my lord, but let it be done at some neutral location, preferably in some public place, my lord, near my home.
Where we will say.
No, let them suggest.
Lordship, may I suggest one thing? My elder sister's house is within the vicinity of 20 kilometers apart from.
There is bad blood between yourself.
But Lordship, it's a neutral party's place, your Lordship.
How your sister.
My elder sister, your Lordship.
And my lord, they are not paying a single
They are
penny
not
towards
alleging that
maintenance
there's
of the
bad
child.
blood between.
I am agreeable for the
House. Any other neutral location?
Lordship, then any place, any neutral place will Katwa, your Lordship, because that is like the half distance.
মানে exact কত কিলোমিটার 50
সবকিছু দেবে
সেটা একবার ইনস্ট্রাকশন নিতে হবে
বাচ্চা নিয়ে পুরো যাওয়া যাবে
ইনস্ট্রাকশন নিতে হবে
মেমোরি পুলিশকে ডাইরেক্ট করুক না একটা নিউট্রাল মেমোরিতে
And the victim is the child.
Lordship, we are not
Every
fighting.
morning
We
he
want
will get dressed up and go to a hotel to meet with her father.
Lordship, we want our wife back. We are not fighting, your Lordship.
They have filed a divorce case, my lord.
No, your Lordship, we never
That is
preferred
what-
any divorce case.
That is what is annexed in this, my lord. My lord kindly sees.
You make up your mind, sir. If you want to make a preponement application there, you go and make. Otherwise, this custody, we cannot allow the child to be.
I am not seeking custody, your Lordship. Only visitation. rights, your Lordship.
Visitation, your child cannot move like a shuttlecock.
Yes,
You take care. You decide that you will go to the child's place and behave properly.
Yes, Lordship, we are willing to behave, your Lordship. Then let it be before the memory police station.
My lord, in a police station, bringing a child would be.
Lordship, then
very
whatever
adamant.
Lordship decides, I will comply with it. But not Lordship. They are not willing to come to our place. Then let that be.
Then we are dismissing the petition. Go and file.
Lordship
There are
kindly
cases
does,
in
Lordship
Murshidabad.
kindly does not dismiss the petition, your
What
Lordship.
can we do, sir? We have requested you. We told your husband to take instruction. We are not wanting the child to be moved like a shuttlecock on the every Saturday and Sunday to a hotel or a cafe where the mother will go and you will come and meet the child. None of you are bothered about your child.
Lordship, I am fully bothered.
So if
I
you are
will
bothered,
provide-
you go. You maintain proper behavior, and if we find that anything untoward goes, we will take appropriate steps against you. Go to the house of the mother.
Lordship, what if we are restrained? Then Lordship, under police supervision, let this be done.
Police has no other word. Police will only go there and finish off your matrimonial dispute.
আজকে তুমি ভাবে জামিন
আমাদের বিরুদ্ধে কেস করেছে sure. My lord, I have just
Who is the lawyer there? You are the lawyer.
Lord, I'm being led by Mr. Bhattacharya.
We are keeping it on 12th November. You filed a preponement application there. We can dispose it just now. Go and
Lordship,
file.
then we are willing to comply. Then passes our order for visitation at their place only.
How can we give you are lodging repeated criminal cases? There is bad blood.
Lordship, that is on a different context, your Lordship.
Oh, I see. It's on a different part.
Lordship, they have stolen some certain articles from our house, which for which we are
Saying does not argue unnecessarily. You are a first-time officer of us. Don't blindly say what your client has told you. Understand the issue inward. It is a child of 2 years. We are saying go to the mother's place. There is a problem between mother and father. You will also not be able to adjust yourself in such a surrounding. I wondered how much time will you be giving to the child. This is the first marriage.
Yes, your lordship.
Oh. Wait.
And for the petitioner, Milord.
My lord, I am appearing for the respondent number 6.
Milord, petitioner's daughter is minor daughter. They are obliged to this court, Milord, just 1 year before. By the blessing of this court, minor daughter was recovered. After 1 year, again, that private respondent has been abducted, the minor girl. Police is not taking proper action, Milord, till date, and asking money from the petitioner's father.
But this allegation is not coming from the bar. But may I file the report?
What is the age of your girl?
17 years, 3 months.
Who is the private
My
respondent?
lord, I am appearing for the respondent number 6, my lord. 6. Rothin Kumar.
The mischief monger.
No, my lord, kindly come to paragraph number 12 and 13, my lord.
You are the person having relation with.
No, my lord.
Then you are.
I am the friend of this respondent number 5.
Friend.
My lord, kindly come to paragraph.
All running on friendship.
My lord, kindly come to paragraph number 12 and 13, my lord.
You have not been arrested as yet.
Oh, my lord. Earlier, a case was filed. In that case, I was on bail, my lord, and trial is going.
POSCO Act was there, my lord.
My lord, and trial is
Unfortunately, they have been
My lord,
released.
kindly come to paragraph number 12, my lord. She left the house for shopping at Chondipur with her brother, but did not return that day. He left his house with her brother, my lord, and kindly, paragraph number 13, my lord, that he believes that her daughter has been kidnapped by Horipada Mondal. No allegation against me, my lord.
Who is Horipada?
Horipada is the respondent number 5.
Have you served upon him, Horipada?
Yes, my lord.
You did not appear on the last date.
My lord,
What is, my lord?
I was present earlier, but due to some exigencies of other cases, I left that time, my lord. My service is there.
Horipada served.
Haripada sir.
Yes, Mr. De.
But first it was, he was.
That I know. Now what is the now?
Now, my lord, I will not disclose. Kindly cease, my lord. Lordship, kindly cease. Because of the clause 10, my lord, 9, I will not disclose this report.
Same person.
Yes, my lord, and police submitted charge sheet
But,
under
look at-
POSCO Act also,
look
but
at the-
unfortunately he has been released.
Look at,
Released by bail.
You are the father. You are the father.
Father.
ঠিক 18 বছর হয়ে যাবে প্রাপ্তবয়স্ক এ 17.5 বছর
the age is very dangerous. Very dangerous.
Mr. Ashok.
My lord, I beg to appear for the petitioner, my lord.
Habeas corpus.
Yes, my lord. There is a correction in the order, previous order, my lord.
Correction.
The second line, my lord, your lordship's order
Yes.
that the petitioner's wife along with his daughter, my lord.
Yes, I have not said that, my
That
lord.
that is the son, my lord. He is kept with me, my lord. Only my wife was abducted.
Only the wife has
That is that's why, my lord,
the
heavy.
child.
No, let us understand the matrimonial problem. Yes, what?
My lord,
You
second
are
line.
the husband.
I am the husband, my lord.
Yes, then
The son is with me, my lord. That is not daughter, my lord. Son is with me. My wife was abducted, my lord. Only wife, my lord. That is my lord wrong.
petitioner's wife. Ashok, by reason of a typographical error,
When I appeared to husband on the last day, my lord wanted us to talk, my lord. I believe something could be, my lord.
My lord, this is my application, my lord. May I be
Wait,
permitted to make
please.
my submission first, my lord? My lord, as per my lord's direction, the parties hold a meeting virtually on this Sunday. The wife wanted to return to the matrimonial home at any cost, at any condition and terms set by the husband. But he did not agree, my lord. Thereafter, he allowed me to visit the child thrice a week for 1 hour, my lord. My lord, that is not sufficient, my lord. All I want my child, my lord. I never had the intention to leave the matrimonial home, my lord. There was agreeable, my lord. There was a matrimonial dispute, my lord.
Child is how many years?
My lord, 2.5 years, my lord.
2.5
Yes,
years.
yes, my lord. And my lord, he was born premature and he's still breastfeeding, my lord.
No.
Now she's being allowed to visit the child.
Yes, my lord. Yesterday she has visited the child. The child has recognized her, my lord. All I want to return to the child, my lord, at any terms and condition put by the husband, my lord.
But I believe we had a different settlement, my lord. Then
Wait, Mr. Chakraborty, we are
My lords, I initially, my lord, from the beginning, my lord, all I wanted to return to the matrimonial home, but he did not agree, my lord, so that, my lord, I had to agree for the visitation for the time being, my lord. I do not have any other option, my lord. I want my child, my lord.
Where do you stay?
My lord, my parental house is at Habra. The matrimonial house is at Lake Town, my lord.
You are a working lady?
Yes, my lord, I'm a nurse. And my lord, I'm working in Binayak Hospital that is closer to the matrimonial house.
The matrimonial house.
Yes, my lord.
So when is your duty over?
My lord, there is no fixed time, my lord. She has shifting duty and twice a week, my lord, she has off days. One night off and one day,
Have you
whole day off.
caused any matrimonial dispute?
No, my lord, what happened, my lord, in this case, I lodged a missing diary for my child, but by influence and in a very purposely, that has been registered as a 498 complaint, my lord. My lord, that was not my intention, my lord. I'm not into making any allegation and counter allegation, my lord. All I want my child, my lord, at any terms and condition that is said by the husband, my lord.
Yes.
Lord, we sat together. We had a settlement. I believe that. Let me put forward that. We said 3 days a week, you come meet the child. 4 days, you have VC. She says 5 days a week, physical visit, and 2 days virtual visit. Now she is saying something else. I convinced my client that 3 days is too less, make it 4 days, and 1 hour is also too less, make it 2 hours. I came with that mindset. Now she is saying something else. With regard to Lord, her claim, Lord, she was studying in Bangalore, as I have said on the last day. I'm carrying that document. She was pursuing the JNM nursing course from 2021. This is a certificate to the from 2021 to 2024. She was in Bangalore. She never raised the child. In July, she left the matrimonial house. July of this year, she lodged an FIR. She says, I have influenced an FIR against me. According Lord, the FIR is dated. FIR is dated 24th July 2025. Page 20 of the petition. And Lord, one more thing, Malad will kindly have a look at that. There is a seizure list annexed. Kindly have a look at this. Page 31. She says, she lodged a missing diary. I converted into an FIR against me. She came back and took all Stridhon articles. Now she wants to come back. Page 31. A lady lodges an FIR against the husband in 31. She took all belongings. 31 of the application. Where is that certificate? ওটা নয় যেটা 24 পর্যন্ত পড়েছে কপি দাও kindly have a look at this. She took back.
Very good. Then what happened?
Then Lord, I lodged.
Have you married somebody? Matrimonial? No.
Lord, I initiated a custody proceeding. Lord, on 5th of August, I initiated the Act 8 proceeding. On 15th of September, she appeared. Then she filed this habeas corpus.
5th of August custody.
5th August custody filed.
And she appeared on?
On 15th of September. And then she filed this.
So did you? When is the next date?
So next date is fixed on 13th of January 2026. Not for the interregnum. What may I most humbly suggest something if my lord allows me? For the interregnum, Let her come, visit the child for 2 hours. 1 hour agreed. But I have impressed upon him that 2 hours, 1 hour is too less. Let her visit the child, be with the child uninterrupted for 2 hours. But on Sunday, my juniors were there. Yesterday, my juniors were there. My juniors were there. She came to my house. My mother came out of the bedroom. She started shouting, why is she coming out? I have a proposal. There is another flat. There's another flat, just 3 houses from my house. Let her come to that flat.
No, later, we don't want to move the child. Child is only 2 years.
Let her visit in my house. Not 2 houses.
Then you give absolute company to her. Let your mother and everybody not disturb her. Let the
Look,
child.
it's not a case of disturbance. It's a small flat in that.
Arrange it, Mr. Chok.
Look, that's what I was saying. This is the main. This is the flat. The centenary building is another flat where she can have uninterrupted visitation. My mother will not go to that house. She will come. I will get the child. She's a 3-year-old child. He goes to school. In the afternoon, I will take my child, my son, from this house to that house. He will have the visitation. My mother would not interrupt.
Child will be left with her.
For flats, I have said that you install CCTV.
Now she would be there alone with the child.
Yes. Lord, I have.
Can she arrange for any meal or any snacks? How can she arrange for?
I'll arrange everything. I'll be there in the flat, in the other room.
Will be there.
Yes.
Yes, madam.
Lord, just 1 more minute only. Lord, I don't.
You are agreeable to 4 days.
My client was agreeable to 3 days. I have not impressed upon him for 4 days.
Right, Mr. Chakraborty is agreeable for 4 days.
They are in court, Lord. But I thought that the mother should have.
How the school hour is how long?
What are they called?
1 hour.
11 to
1
2
hour.
is the school hour.
11 to
11 to 2 p.m. is the school hour.
no, child is only
But
2
play
years.
school, 2-3 hours play school goes on, Lord. From 11, he goes at 11, comes back at 2 p.m. Later come back anytime after 5.
My lord, regarding the duty hours of the petitioner, my lord, it is not possible to visit on the date after 5 p.m. every time, my lord, because she has shifting duty.
Yes.
Then go to the custody.
He appeared in the custody court.
My lord, with regard to the allegations, my lord, that she has not raised the child, my lord, that is absolutely false. On the relevant time, my lord, she was pursuing.
Record that. We shall record that.
My lord, may I submit, my lord, on the relevant time, my lord, she was pursuing nursing duty, but
Madam, we cannot hand over the custody to
Hmm.
her. Your guardianship application is there.
yes, my lord.
He has made a prayer for custody. You oppose that custody. And in the meantime, we can give you visitation right. But we cannot at this stage say that hand over the child and face the custody courts. That will be difficult for her also. Try to appreciate it is a human problem.
My lord, kindly allow me visitation in such case, my lord, at least 5 days a week, my lord.
Will you do your job or every day?
My lord, I am a mother, my lord. I will manage somehow, my lord. I will do anything for my child, my lord.
Ask your client not to insist.
Yes.
Let to visit peacefully. Let the child be in a comfortable atmosphere.
My lord, she will, my lord. She will, my lord.
And then what is the address of the other flat?
ময়ূর অ্যাপার্টমেন্ট 13 অজয়নগর কলোনি কত দূরে তোমার বাড়ি থেকে কত দূর
500. Why
500.
Mr. Chakraborty, if she goes to your place, what is the problem?
Let her come, I don't mind. Only thing is that I tell you also, only thing is
There
that
is no separate room. Your mother will be there.
in the dining room,
Why?
she has a problem with my mother. Look, the flat is empty. The flat is empty. It's my flat. Lord, she wants to have the visitation or fight with my mother. What is the point? বিয়ের পরে তো এটাই সমস্যা মাকে ছাড়ো বউকে ধরো মাকে ছাড়ো ছেলেকে ধরো এই তো প্রবলেম This is the problem. ওই অ্যাড্রেসটা লিখে ভদ্রমহিলাকে দাও
No, it is an empty flat. Now the child will not be comfortable.
There is a bed in a room, small bed.
Understand, but there is you are living in the other house. You are living it in the other house.
I will arrange everything because I tell you also what I'm What I'm fearing.
That what is your problem? You have any problem?
No, my lord, I do not have any issue with any place, my lord. I just want my
That place you are having any problem?
No, my lord, I do not have any problem, my lord.
Whatever is necessary, we'll arrange.
Last day also there
What
was
do
no
you
chaos.
say? What do you say as regards these facts which we have stated to us? That 3 years you were
Yes, my lord. At a relevant time, my lord, I was pursuing my nursing degree, but there was no physical class, my lord. I attended Bangalore only for 15 days for exam purpose, my lord. There is the routine and the result, my lord. If my lord,
saying from 21 to 24.
my lord, that was the course period, my lord, but there was no physical class at that relevant point.
When did
She
you
was
get
pregnant.
separated?
My lord,
When did
my
you
lord, she left matrimonial home on
Second of
2nd of July 2025, my lord. And she joined duty and she returned on 4th July evening. And from there, from then onwards, she found the matrimonial home under lock and key. And there was no contact from their side.
Complaint lodged on 24th July after
Yes, my
20
lord.
days.
Before that, my lord, I tried to find the child each and everywhere. I also text the relatives of the in-law side, but I could not find the child, my lord. If my lord kindly remember the annexure at page 25, my lord, how the child was snatched from my.
Snatched.
Yes, my lord. If my lord kindly sees the picture in Hashnabad, my lord.
What is the utility of these submissions? Tell us.
My lord, there is no utility. All
Fair issue involved of the child.
Yes, my
There
lord.
is an acrimonious relationship existing. Now
Yes,
you
my
are saying I'm willing to comply with everything.
Yes, my
He
lord.
sitting in habeas corpus cannot decide your husband-wife problem.
Yes.
Try to appreciate this.
My lord.
Can we do so, madam?
No, no, my
There is a matrimonial issue. We can request the husband and the wife to sort out the problems at the sake of the child. But if none of you are so stubborn, what can we do? Tell us. Maximum if she is a mother, she must have an exposure to the child. That is to be ensured. But in view of this counter allegation, will it be possible for us to go into the merits? Custody is it cannot be miss.
What
So it will be on 4 days.
Monday to Thursday, from whatever time she says.
Give her the weekend.
Weekend.
My lord, the petitioner does not have any specific weekend, my lord, according to her profession. There is no Saturday, Sunday.
What do you want? You don't want the weekend? Do you
কাজের পরে ফেরাটাই
are
better.
you wanting inclusion of weekend or not? Tell us. We will
My lord, inclusion of weekend, my lord.
That's what we just said. We just now said. So you will be there for, say, Thursday, Friday, Saturday, Sunday.
My lord.
Huh?
My lord.
And tell us the time.
Time. এরকম করলে কি করে হবে?
And if not said, again there will be problem. You are also in problem.
Then
My lord, that is a practical difficulty, my lord, in her job, my lord.
Ask your client not to open her mouth here. You are representing him. Yes.
My lord, according to duty, my lord, there is no fixed duty hours, my lord.
Oh.
There's a practical difficulty, my
So
lord.
the child will go to the nursing. It is better. We will ask husband will sit with the child. When your duty is over, he will come.
My lord, kindly give me any
She
time
is
after.
testing the presence of the patience of the court.
I beg your pardon, my lord, on her behalf, my lord. Kindly allow me any time after the school hours of the child, my lord.
আমিও চাইছি বাচ্চা আপনি যদি কথাই বলবেন লয়ার রেখেছেন কেন? Child normally has dinner at 8, then he will go up to sleep.
You tell us.
Yes.
My lord, any time after the school hours of the child, my lord.
Yes.
Any time after the
School hours of the child, my lord. Any time after 2 p.m., my lord. The school is over at 2 p.m.
4 to 6. After school he will come, have lunch, then 4 to 6. I don't mind. 4 to 6.
If your duty is there, we will make it 4 to 7. You come and visit.
My lord.
If you are in trouble, arrange your duty in that fashion.
My lord, I will arrange, my lord. I will arrange.
The present treatment.
I appear on behalf of the petitioner. Your Lordship, to complete.
Yes, madam, what is the matter?
May I please, my lordship.
This
matter,
Naveen Kumar Chanthiran.
I am appearing for petitioner, my lordship.
Well, I'm for the state in this matter.
This is a petition for habeas corpus, my lordship, to bring back the wife of the petitioner, my lordship, who is staying in the parents' house in West Bengal, my lordship. From the date of marriage, my lordship, the girl was house arrested by the parents, my lordship. Till date, he was not.
But I appeal on behalf of the private respondent.
Wife.
My daughter, my lord. Regarding this case, I am a father.
You are responding.
Report to the judge.
Respond number my lord 4.
Copy আছে তো কাছে?
What happened?
Report দিয়ে দাও।
হ্যাঁ এইটাই একটাই পাঠালো দিস দেখো না
নেই
ম্যানেজটাই তো খালি হয়নি এখন কোশ্চেন লিখে আছে বলো
এই বলছি ব্যাপারটা বক্তব্য দিয়ে দিয়েছি তুই পড়ে নে রিপোর্টটা এই তো দিয়েছে ফোকাস হবে
মালয়েশিয়ান পার্মানেন্ট রেসিডেন্ট এখানে একটা মেয়েকে মন্দিরে বিয়ে করে বলছে নিয়েছে বিক্রি করবে
So it has been settled.
It has been settled.
It has been settled, your wife has, that is what they say.
And not the wife even. It's a girlfriend. No sign of marriage.
My lordship, kindly see the page number
Here
18
is-
of the annexure, my lordship.
Yes, sure.
In page number 18, my lordship, the girl was married with the petitioner by exchanging garlands, my lordship, in a simple temple, my lordship.
So very good, but where is the marriage certificate?
The marriage was not registered, my lordship. They met with a matrimonial profile, my lordship. Afterwards,
You file a matrimonial suit. Why you
no,
are,
my lordship.
what habeas?
Because in page number, kindly see the page number 33, my lordship. After the conversation with the girl's parents, my lordship, both the parents are jointly taken a photographs, my lordship. Thereafter, the daughter's father, my lordship, house arrested the girl, my lordship. And therefore, page number 38, my lordship. Kindly take page number 38, my lordship.
What I mean, you are not willing to,
My lord,
he is not your husband.
Your lordship will come to the last page of my report, my last page, the back side. The lady has made a declaration.
Malaysian permanent resident, he claimed that before the
Last page,
temple,
yes.
my lord, he married and going to my lord, Malaysia without valid document, without performing any marriage. And my lord, I don't know he is a Muslim or Christian or Bengali. No, my lord, stated in the affidavit.
Kindly see my affidavit, my lordship. We have clearly stated that we are a Hindu. His name itself, in fact, that the name is Naveen Kumar Chandran. It's a Hindu name, my lordship.
Yes.
Therefore, the humble request, my lordship, kindly go through the page number 38, my lordship. The Ria Thakur, who is the daughter of the fourth respondent, my lordship, has sent a notice to the petitioner.
Listen to us. The girl is an adult lady. You are listen to the court first.
Yes, my lord.
Keep quiet and listen.
Yes, my lord.
The daughter is an adult lady. The girl is an adult. You are an adult. You are alleging that there is a marriage. She is saying that there is no marriage. So these allegation and counter allegation, how can the writ court determine? Got it? Habeas corpus is illegal detention.
Yes, my lord.
So if it is an illegal detention, this cannot be proved here before us.
But my humble submission, my lordship.
There is a matrimony, if there is a, see, we need not advise you. You know very
Yes,
well
ma'am.
that in relation you can go and file for restitution of your marriage, which you say that it happened, but it was not registered marriage.
It is humble submission, my lordship. Please go through the page number 38, my lordship. The girl has sent a notice, my lordship, through the petitioner through a WhatsApp, my lordship. She clearly states that he is in a danger, my lordship. That she is in danger, my lordship.
Heard Mr. Devanthiran.
Devendran.
We pronounced it wrong or what?
Devendran.
Yes, we have made the right pronunciation, na?
Yes, my lordship. Yes, my lordship.
Heard the learned advocates appearing for the respective parties. No. Heard Mr. Learned advocate appearing for the petitioner and Mr. Panda learned is appearing for the state respondents. Let the documents come as produced by Mr. State respondent. Stop. Mr. Learned advocate appearing for the
Monishankar Chattopadhyay, private respondent number 6,
appears for
led by Mr. Gopal Mondal.
give some more names now. We will
Well, Gopal Mondal,
Gopal Mondal, give some more advocates.
he is also.
Mr. Learned advocate enters appearance on behalf of the respondent number 6 and press for the file an affidavit in opposition to the writ petition. Stop. Let such affidavit in opposition.
4. It is not 6, but 4.
4 করে দাও। Let such affidavit in opposition be filed within a week after the vacation with a copy to the learned advocate on record. You are the record.
I'm not on the record, your lordship. The learned
Then
advocate
how
appearing.
How he will give the copy?
He can just take my contact number. I will contact.
Please give it with a copy to the learned within a week after vacation with a copy to the learned advocate appearing for the petitioner. Please the matter for further consideration in the daily reply thereto, if any, be filed within a week thereafter. List the matter for further consideration in the daily supplement list of this court on 19th. Yes, next.
Your point of maintainability will not
Since we have filed the report, we need not file any further affidavit, madam.
We have not said.
But point of
Let him
My humble submission, my lordship. My humble submission, my lordship.
A copy
Let
of the
let the girl may be present before the court, my lordship, and she can tell anything, my lordship. If he willing to live with the petitioner, there's no one can stop, my lordship.
We are in habeas corpus.
Milord maintainability. Okay.
But come with the affidavit. Maintainability, everything, take in that affidavit. Yes.
What come on?
Yes, 14. What happened, Mr. Pandey? Any information?
My lord, your lordship will kindly see, my lord. এটা একটু judge সাহেবকে দিন তো।
What tell us now? Tell us now. What?
That the mother has sold the baby. This is the on a stamp paper, my lord. It has been done. For that reason, we did not hand over the baby to the mother. We gave a protective stay for one night. Then we referred it to the CWC. CWC has conducted an inquiry, and she is willing to appear before your lordship and depose. Whatever she has not handed the CWC Howrah.
Now, where is the child then?
Child is in the home, my lord.
Then what is the problem, sir? You are the.
I'm not sold my child, your lordship.
You
sold. It says স্বইচ্ছায় দিয়ে দিল।
And
They are
she will
taking
not
care
pay
of
any-
my child. I have. Lordship,
My lord, this
I
has
have
been
kindly-
corroborated by the.
Your lordship, allow me to
Act
please
second,
give
act second.
information.
This has.
But it is.
আমি
I'm
একটু
not
জজ সাহেব জিজ্ঞেস করছেন, আমি বলতে দাও। My lord, this has been corroborated by the parties before the CWC.
It's a different thing. You've handed up this.
CWC should have been made a
application
party,
and
my
you
lord.
say It says that's the petition case also.
that they had given it to somebody else because of the.
Your lordship will kindly visualize a mother is handing over a baby of 45 days to another person.
See the circumstances, Mr. Panda.
No, what are the circumstances? I can leave my baby of 45 days to somebody else. I ask this question to myself, my lord. And she is saying that I will not claim. On the basis of this, when we got the information, the police has taken a protective stay for one night. Thereafter, it was referred to the CWC. CWC has made an investigation, total investigation. And she has not been made a party. She was supposed to be here as a party, my lord.
I submit, your lordship.
Yes.
Lordship, I have not sold my child, your lordship. I have.
You know the whereabouts of the child, na? Child is at a center under CWC. Go and meet with her child.
I am back my child, your lordship, because I have a 3 child, your lordship. So they have taken care of my child because of
child. She 3.
Already I have. It's my 4th child.
So 4th child.
Yes, your lordship.
Where is your husband?
My husband with me, your lordship.
Then why did you hand over the child?
Because of financial hardship, they are taking care of my child. It's in my. They are also my family relatives, your lordship.
So now you want, you gave over the child to some other relative.
Relatives, your lordship. They're taking care of it.
No, then what happened? You gave it to the relative.
Then someone make a complaint to the police, and police did not hear me.
What complaint did you make?
They are claiming that I'm sold my child to them.
Well, that is one aspect, and second is
yes.
But I'm not sold my child, your lordship.
So now the child is at the CWC home.
Yes.
If you want back the custody, you go and approach to the CWC. That is the law. Why you are coming to us? It is not a case that the child is missing. It is they are alleging that you have sold the child. You are saying that no, due to financial stringency, we handed over to such persons. Now, how did the police get hold of the child from the
police get hold of the child?
Well, informations are given to the local police station, and these are sort of illegal adoption. Whenever there is an illegal adoption as per Juvenile Justice Act, when the police will act, they will take it to the protective home, then they will report it to the CWC. CWC then takes over the thing.
Where is your documentation to that effect that you give?
Well, the CWC should have been made a party. She should have come, and she is not been made a party. And these reports are not being handed over to us, my lord.
Which report?
The CWC report is a confidential document. She said that she can only hand over to the court, not to us. So if she is made of...
But the council...
I am the council, not the CWC is not a party here, my lord. That's why it was not handed over to us.
Now those persons are here to whom she handed over. They have been implemented here.
1 second.
We have. They have not been implemented.
No, Ilwa Children's Home is a party. Is a
very good. Now
the person to whom you had given the child, you have not made them
party.
You have not made the CWC party.
Lord, refer it to the CWC, let him file application before the CWC if you can prove.
You withdraw the petition, we will give you with leave to approach the Child Welfare Committee.
Yes.
You have the capacity to take back the child now.
Yes, I'm trying with my best. You're taking care of my child.
Do you have the financial capacity? You have the financial capacity.
Yes, your lordship, for what I am giving to my relatives, my child, but I am taking care of him, your lordship.
Do you have instruction? Did you go to CWC?
Give me 1 day, your lordship.
So then do it. The matter can be solved. What they are saying is it is with the CWC. You go and contact CWC that due to financial stringency I gave over. Now I am willing to take back the custody of the child.
Very well,
CWC made paper publication as well.
Kindly, your lordship, give me 1 day for taking proper instruction. I am coming tomorrow, your lordship, for.
Come after the vacation. It's a hard Mr. Day. As Yes, Mr. Panda, we called you for this reason that you said na CWC. We were thinking that whether you can, that another matter of yours we passed an interim, the adoption, putting into adoption. Is there any such possibility?
I hope so, because there has been a publication and it has been declared free for legal adoption. Up to this stage,
It has been declared to be
free for legal adoption.
Oh,
To
then
that
it,
stage it is over.
then,
And
then
now,
it,
now, for that reason, I said that if the CWC appears before your lordship, then it becomes easier.
yes, it just struck our mind after we went down that we remembered another matter of yours wherein we said that don't put him up for adoption.
We prayed for that.
Yes, yes, you prayed for it. So can you do one thing? We keep it tomorrow. Can you inform that person to the petitioners?
South India থেকে
No, no. Somebody was, ওই যে ওইটা অর্ডার করলাম না ওটা তাহলে লিখো না। মিস্টার পান্ডা, আচ্ছা অর্ডারটা থাক, কালকে সই করে দিচ্ছি। Order. Yes, we will keep it, we will sign the order, directing it to appear tomorrow as to be mentioned. Please give a notice, and if you can, that if it is free for adoption, then everything will go. That you kindly
That will
inform
be
us.
state my lord subject to the
Yeah, then you inform us tomorrow. Can you, do you know that advocate?
I'll see.
Thank you. Sorry, we disturbed your project. Yes.
Item number 4 and 5.
Well, that too matter, my lord. This is our reply, my lord.
স্যার আমাদেরকে হার্ড কপি দেবে ওখানে
Hard copy, please.
ঠিক আছে সরি
You have finished, Mr.
No, well, as
Chakraborty.
far
We
as
shall hear Mr.
As far as maintainability is concerned, I have finished. But the question of merit, lordship was kind enough to direct me to place it on the subsequent. But I shall not take much more time. Only, my lord, I will place some judgment and 2-3 question of merit, my lord.
Lord, we also file an application raising the maintainability issue. Let our application be decided first.
Such a theory in that Sinur, some Sinur alam or something. In that case, those 2 persons were brought back. Is there? We are not saying anything. Is there any such possibility in this case?
Lord, so far as
Mr. Trivedi appeared, that Odisha government matter.
Odisha government, I was just asked because I can speak
yes, yes.
in that language also. Milord, I was,
Odisha and Rajasthan also, my lord.
I don't
Rajasthan
know,
case also.
Milord, I suppose they were not deported in that case. They were in Odisha, Milord, and then the order was called back. Here, Milord, the situation is totally different. These people have been deported and nothing has, the Bangladeshi Commission has not registered any such man that they are Indian citizens or anything of that. So, Milord, we are totally in the dark. They have been, Bangladesh has taken them back.
yes, they are staying there.
Yes,
No, well, they are arrested and the case has been initiated. They are arrested. Yes. Arrested.
We don't have any such information. Police, Milord, his clients, Milord, he'll be doing
Then
better.
suppose we hold in your favor also. How can they, if they are in connection with any case in Bangladesh,
Lordship.
how can we
No,
back?
my lord, in generally, my lord, in Amir Sheikh from Rajasthan deported to, my lord, the Bangladesh. When this court was in Sessin, my lord, some people took initiative to file application before the court of Bangladesh for his bail, and bail was granted. Then, my lord, he was loitering, as they said, BSF said, he was loitering in the yes, my lord.
Mike, your voice is already
because
loud.
of deeply obliged. He was loitering in, my lord, loitering in the border as their case is, and he was taken back. So, my lord, the same procedure and diplomatic relationship with Bangladesh and India is, my lord, some problem. And repatriation.
What procedure was followed in that?
Well, they prayed for bail in Bangladesh court Foreigners Act, arrested and bail granted, keeping in the mind they are, my lord, Indian citizen. And then he was taken back.
But why was he arrested? What was the ground?
He was arrested. He was in loitering in the Bangladeshi land without any valid paper. He was deported, pushed back to, my lord, Bangladesh, and he was arrested. They also arrested, my lord. They are Foreigners Act. And they are also arrested, and in a particular district, Chapai Nawabganj district, in Chapai Nawabganj district.
My lord, by my junior, my lord, I have been intimated that is on a different factual matrix because I am not there. My lord, my counterpart is representing. My lord.
Very good. It cannot be done as done in other matters.
Yes, my lord, that is what I'm saying. My lord, he, if at all he has, I've been told, my lord, of the cuff that he has again illegally infiltrated into India, and in India necessary steps have been taken against him. And my lord, that matter is pending before your lordship.
This person,
no, my lord, the person who's referring,
Amit Sheikh.
the story which is being, the case which is being referred to by my learned friend before your lordships, it's on a different factual matrix, my lord. My lord, as far as this is concerned,
this is different.
Yes, my lord, on the fact that he has what, as far as what happens, my lord, normally why my understanding is, if a person is deported by us to Bangladesh or to any other place, my lord, and if he is arrested as a foreigner in that nation, a letter is sent to us, our commission there. Ki, look here, this person has come. We have arrested him. You please take him back. But no such letter as far as today's information is concerned. The police, I don't know.
No,
my
no,
lord.
there is no information. At least not in Indian High Commission was not at all informed.
My lord, that happens.
Let it be
So
declared.
you don't want him to come
Yes,
back.
certainly, my lord.
Only
One is
detention and
advanced
deportation.
pregnancy is there. One person, Sonali, is there. My lord, they are incarcerated in the jail. My lord, definitely, my lord.
We are asking that
Lordship.
what is the procedure for taking them back,
My lord.
even if we hold in
Yes, my lord. If that be done, my lord, in that case, diplomatic relationship between the two countries are there. They will ask, my lord, to bring him back. To bring him back. My lordship knows, my lord, in number of cases, including very recently.
Suppose there is a procedural network.
Lordship.
We don't know whatever may be the news.
Yes, my lord.
We don't know that what is the present status, where is it?
True, my
Anyway, why should you, when they are saying that it is not possible, because otherwise
Yes,
information.
but kindly hear this.
There must be some information.
Kindly-
Till date, there is no
Kindly hear
information.
this matter and conclude it.
Yes,
my lord.
yes.
You have taken enough time, my lord. No more, my lord. Kindly see, my lord. There.
Else you want to point out?
Yes, my lord. There affidavit. I am to draw lordship attention.
Yes,
Affidavit.
yes.
They have shown, my lord, certain inquiry which is preceded.
Affidavit of
Affidavit of my lord Neela Prasad,
Milord,
daughter
before-
of Sri Chandrabhushan Prasad.
Milord, before my
Affidavit
letter starts,
by 1 to 4.
Milord, can you, your lordship, Milord, can you hear our
We'll hear you.
application, Milord?
Both we will hear. We'll finish it off.
Yes, my lord. Deeply obliged, my lord.
Please
Lordship,
make
kindly
your
see-
submission on maintainability as well as.
Yes.
Yes.
Kindly see, my lord.
You, Kati, we have already heard you.
My lord, they have filed certain new document. Let me allow, my lord. I shall take, my lord, I undertake not to
Only,
consume
only
much
Milord,
time,
only Milord, so far as the state is concerned.
consume much time, my lord.
Milord, today,
Yes, sir.
yes, I have heard, Milord, your lordship.
Don't tell me.
No, Milord.
Yes.
Yes, kindly see, my lord, the affidavit.
Your lordship, no, no, আমি বলছি যে,
বসুন।
so state is concerned, My Lord, your lordship, kindly hear, my Lord, learned advocate general is not here today.
So, sorry, we cannot do that.
We are also opposing.
It's my prayer, my Lord.
Mr. Banerjee will argue.
It is my prayer, my Lord. My lordship,
You
kindly,
will argue now.
kindly consider.
Yes.
My lord, kindly see Lina
Yes,
Prasad,
correct.
daughter of Sri Chandra Bhushan Prasad.
Page, what year they are showing us?
My lord, affidavit, my lord, page 30, 1 to 4.
Position দেওয়া হয়ে গেছে।
Page 1 to 4. This is a new affidavit in opposition filed by the Union of India.
না, দাঁড়াও না। এই কোনটা?
মাল লিখে দিয়ে দাও।
Page 30.
Plus, you got it. Name at the top, Danish. At the top, format for requisite particular in nationality status verification.
Now, one thing, tell us, this is same as the other one?
No.
Other one?
Other one is same, almost. Yes.
Yes.
Same, my lord. I shall not touch that matter.
Page 30.
Page 30. My lord,
No,
kindly.
in that matter, affidavit also, this
Yes,
is
yes,
given.
yes. Everything is copied.
Checked up.
Yes. At the top, my lord, name Danish,
Yes.
the husband of Sonali. My lord, surname Sheikh, father's name Manu Sheikh. Kindly note this Manu Sheikh. I will show number of paper of Manu Sheikh.
Please make it concise.
Lordship. I'm trying, my lord. I'm drawing lordship attention. Kindly note, my lord, name of the Manu Sheikh, name of the mothers, column number 4, Dilbuba. My lord, then I'm skipping some column. Kindly come to my lord, column number 10. Occupation at present, labor, driver. Then turn to next page, my lord. Page 31. 12. Name, telephone number, address, and telephone number of two respectable person, known person of the area, e.g. Sarpanch of the village, municipal schoolmaster, postman, councillor, city, and other respectable person for reference, not known, my lord.
Now, of the area means which area?
From area, from where he was arrested. This is the inquiry. This is, my lord, at the top. Requisite particular in nationality status verification. They are doing this verification. So when they, my lord, arrest him or take into custody, they have to do this, my lord, particular formality, their own, my lord. I'm skipping this point. Next, my lord, 32. Interrogation report. Top, my lord, interrogation report conducted at the office of, my lord, Blood. Possibly, my lord. SHO, my lord, that is, maybe it is a fault of Xerox. My lord, kindly come to the next, at the bottom. 14. Detail of the family, father, Munna Sheikh. Then, my lord, kindly come to page 33. 15. Voter ID card, no. Driving license, no. Passport, no. Ration card, no. Aadhaar card, no. My lord, Aadhaar, ration, voter, driving license, all are available. I'll show, my lord. Then turn to next page, my lord, page 34. Is the father who has filed this case before this honorable court.
She bears your signature.
My signature. My signature. My lord, in the police custody. In the police custody. An evidentiary value may kindly be considered. No, lordship, kindly 34, 35. Here also, item number 12, blank. Now, my lord, interesting thing is page 30. Shunali. Page 36 may kindly be looked into. 36, 17, 18, 19, 20. Date of birth, year, 26 year, they have calculated.
This is the
Shunali. First is husband.
Yes.
Then Shunali, 25.
30 detail of the family, detail of family.
Detail of family. Manu Sheikh.
Next page it is given members and where they are deciding.
Yes, my lord.
Then where is the address of this Danish?
Danish address, my lord, as it written here, my lord, page 32, column number 6. Juggi number 285, sector 26, Rohini, Delhi. Rented. Page 32, 6, column number. And address is Bangladesh is also written.
No, we are not trying. Here the interrogation was, who are
Yes.
your family members and where are they residing? That is clause 12.
12.
30, sorry, detail of him.
That page number, Lordship is indicating. Shunali.
You have shown us.
My lord, kindly see, my lord, 26 year old, then 25. Date of entry in India
is 98.
8. Then, my lord, in the 26, her age should be 28, at least.
You are very good in mathematics, it seems.
Oh, my lord, not that. Lord, we know, my lord, we are for some helpless people. my lord.
Mr. Tiwari is not so good in mathematics.
Then, my lord, kindly come to, my lord, I'm skipping page 44, my lord.
He only wants patented. I will argue.
My lord, is scored, my lord, secured 0 in class 8 half yearly examination in mathematics. But
Zero.
I know, my lord, how far I can run so far mathematics is concerned.
Then you should.
Well, that particular precious document which was handed over to this honorable court and taken back on that date. Here, my lord, name of at least 163 persons are appearing. For them, my lord, there is no place in India. My name is appearing 61, 62, 63.
No place in India means they have been
But
deported.
they have declared at the bottom.
They have been deported.
Deported.
Your name is
shall not remain in India, shall depart instead of deport from India as soon as possible. My lord, page 44, my name is 61, 62, 63. Then lordship kindly come to my lord. Now, my lord, on 24 they have decided.
Oh, your son was date of birth of your son.
My lord, Shunali. Shunali is the wife. Shunali's son.
Shunali's son, date of birth of your son is 7 years.
7, 8, yes, sir.
Then he was born in India.
India.
Then where is the birth certificate?
Well, yes, I'll show. That is with I have enclosed.
That is with you there.
I have enclosed. Then my lord, kindly come to page 60. I'm showing.
Yes, you told.
May I show my lord page 60?
60. Now you want. You have showed us your serial numbers. You have showed us.
Yes.
Now next.
Then page 60 may kindly be looked into.
Page 60.
60.
Yes.
Page 60 petition. Page 60, my lord, here in the middle, my lord, date on 23/6/2025 when it was moved before the Honorable Delhi High Court. My lord, they found no document, and this particular notice was given to them that we have filed a case annexing certain important document, the column of which remains blank as far as inquiry is concerned. My lord, kindly see page 60 at the middle of portion.
So how will we know that this was given to them?
I'm showing, my lord. Page, then I am showing next page. Lordship, kindly come, page 61. Notice of motion.
This is of Delhi High Court.
Delhi High Court. True, but it was within their knowledge. On 24th, they have adjudicated. And the papers and documents which are not lying in inquiry, that was available in the Delhi High Court when the matter was moved. And 23, it was filed, 24, notice given. And again,
so when
urgent application.
No, they filed that status report.
Yes, my lord. Status report, but on the basis of their inquiry. In inquiry, they found no document with us. But in court, we have annexed certain document which they did not
say there was no document. Their plea was that.
Say, my lord, kindly see once again. My lord, kindly come to page 33. Nil. Page 33 once again, my lord.
Oh.
Column number 15.
Yes, your voter card ID, etc.
Yes, my lord. Then I am showing, my lord. Page 64. Including the name of the investigating officer, Sourav Malik, mobile number, notice of motion, urgent application, page 64. That is on 24/6/2025. On the date, FRO adjudicated. And then, my lord, I am showing the document. They enclosed it. It is.
No, what you are showing from page 64?
60, my lord, I am showing. It was before the Honorable Delhi High Court when we moved this application.
What
rightly.
Is the date of this memo?
My lord, I am showing, my lord. Page
60
is, my lord, the middle portion, lordship will find.
23rd of June.
Yes. And 24, it was adjudicated before the FRO.
Right.
FRO. Then, my lord, kindly see.
Then what you are wanting to show us?
Show, my lord, they are of the opinion no document is available with the detainees, but documents are lying with them, certain documents. Since they are in Delhi, they are keeping this document, and with the help of that document, they filed the writ application before the Delhi High Court. They are aware of it.
The page 60.
Yes.
The entire petition with all the voter card.
Yes. Then, lordship, page 97 may kindly be looked into annexures.
You took us to page 64.
60 for the reason that we have informed them that matter we are going to move before the Delhi High Court. Notice was given. The said petition enclosure is page 97.
Check 23rd.
This is 23rd June ID number. ID number. First data, first data.
That is the second writ petition at page 88. What my lord friend is showing at my heaven.
First writ petition also you have enclosed all those documents. I am showing.
No, your first read petition is page 60.
60.
What is the number of this first read petition?
First writ petition, my lord. The document they have enclosed, number is blank. 3208, page 60, my lord. Of 2025. Page 60, my lord, middle portion. Criminal matter thereafter. Oh no, yes, my lord. 3208.
That is DD number.
Yes, my lord. That was at that point of time, that was the number.
DD number. Anyway,
Yes,
what year page 64 you have shown us?
Yes,
The diary number is this, and
yes, my lord. We
SI
have.
page 66 is the second read petition.
Yes, my lord.
But that also diary number is same.
That is why, my lord, I am of the impression both are same. 3208, page 81. My learned friend indicated this is second matter.
May I interrupt my learned friend once? My lord, only one thing, my lord, may I say?
We will
My lord,
finish up.
kindly, my lord, hear our maintainability petition first. Kindly, my lord. Kindly decide it, whether it is maintainable or not.
Told you, Mr.
One liner order, my lord, would be sufficient for us. Even if
You are
rejected.
insisting so much. We have rejected your prayer.
No, not rejected. Not rejected.
Time and again submitted this question, your lordship has not recorded.
Well, not rejected.
It is well settled principle of law of this judiciary. When a maintainability question is raised time and again, that is to be decided first.
Why you are so agitated? Ato, why you are so agitated? Go to the higher forum. What is your no? What did you just now say? That to give us an opportunity to go to higher forum.
Because maintainability question, if it is decided against us.
That we also know.
Yes, yes.
That is, so you are already saying that we have made up your mind to dismiss your petition.
No. Your lordship is saying your lordship has decided the maintainability issue.
We have not decided. We have said we have Mr. Chakraborty. Please cool down. First of all, this is not a place. I am also cooling
Yes,
down.
the last occasion when I finished my argument went now.
Yes.
And Mr. Trivedi wanted to record my submission.
Yes.
The lordship took him to task and said, your
Oh, you are coming for safeguard. Yes, Mr. Trivedi. I told you. You are wanting to safeguard.
Safeguarding it. Judicial propriety demands the question of maintainability has to be decided first.
We will hear to your maintainability.
First, it has to be decided.
To come first. Come first. Then tell us the merit.
Yes.
You will not stop. You will say maintainability and merit.
I shall not go to the merit.
Achha, very good. We have rejected your prayer.
Very well. Thank
Yes.
you. Pass an order.
Yes, we will pass.
Pass
Yes. Submit.
Kindly see,
Mr. Chakraborty, you are a very senior person.
Your lordship is also a very senior judge.
Yes,
Very
please.
unfortunate
What
that
unfortunate?
one particular question of law
His voter identity. Then Lordship kindly come to page 98. Shunali Khatun, Government of India, unique identification, that Aadhaar,
Page 97.
97, 98, all the documents, my lord, it was supplied by them, my lord. 99, 100, 100, my lord, the petitioner's name is there, Bodhu Sheikh. Then, my lord, what I intend to show now, my lord, our reply. The name of our father, mother, the other things. Lordship kindly come to my lord, page 46, 47 of our affidavit. Affidavit by the Bodhu Sheikh. Affidavit in reply to the additional affidavit in opposition filed by respondent number 1 to 4. It's my affidavit. Lordship will find, yes, sir. Page 47.
See.
Letter.
So you have shown us 98, 99, 100.
100. Then, my lord, our affidavit. Reply of Bodhu Sheikh against my lord 1 to 4. আমার কাছে sample করা আছে। Yes. But here, Lordship kindly come to page 47. The document of the father of Danish. Date of birth 1965. Page 47. Lordship got it?
Yes.
The document of the name of the document of the.
Your contention is that they themselves have included
Yes.
documents which they are saying in the interrogation that it is not.
Yes, not there. At the same time, they
Bodhu Sheikh is you are this is your
yes, my reply.
they annexed
Yes.
Bodhu Sheikh's card with the
Yes,
application.
1 to 4. That reply, their reply. Against yes.
You have not shown us that. Of Bodhu you have not shown.
Yes, sir. This is what I'm trying to draw Lordship attention. Page 4. Bodhu Sheikh. Bodhu Sheikh.
This is Manu Sheikh.
Manu is the father of Danish. Page 30 of their affidavit. We have enclosed this document. The father, date of birth is 1965. Necessary document we have enclosed here.
But this is not there in their affidavit. It is your affidavit.
My lord, they disclose the name of Danish father, page 30 of that affidavit. From that, taking cue from that, my lord, we are furnishing the document of the Manu. Then, my lord, turn to next page. Next page, my lord, Lordship will find 47, 48, my lord, the same. Then, my lord, epic card, page 49. Here also, my lord, the voter I card. Here name will find at the bottom, my lord, Manu. And date of birth and other things are available there. Page 51, mother of Danish, Diluba, they disclosed. Name of the Diluba disclosed in page 30 of their affidavit. This is a document relating to Diluba. And the page 55, they are in possession of land, their owner, Rayot. Diluba. Deed, my lord. Everything is there. Lordship will find this document will show they are, my lord,
All right. Anything?
resident of, then, my lord, only I intend to realize certain judgment, if lordship kindly permit me. Judgment relating to this maintainability and all this, and maintainability I have on the last date. Now, my lord, today itself the other judgment are there. Lordship at the same time, number of point one, including Lordship Supreme Court was kind enough to declare, or my lord, direct or rather request this honorable court to decide the question of citizenship. So that is required to be placed before this honorable court. They are citizen by birth. And my lord, number of judgment, I just indicated the paragraph. I am giving them the copy.
By birth, what document you are saying?
I'm showing, my lord, this document I have just shown. Their father here, 1950, 1960, 65. Thereafter, my lord, they are living in the Birbhum Paikar, and they are permanent resident of that particular area. And well, landed property also, everything. I'll show, my lord.
Is of your father.
Yes, because of if today, my lord, is father property. Tomorrow it will be mine. I'm sure. I'm sure that I have indicated, my lord.
Where is the birth certificate? You said
Birth certificate. Next birth certificate. It was my landed friend is, my lord, in search of that. I'm just handing it over. My lord, indication is there. Paragraph is also there. I'm just, my lord, drawing at least, kindly allow me to draw at least one judgment when Honorable Constitutional Court declared citizenship. So far other things are concerned, I have given them my details. But to cut short this matter, my lord, judgment wanted by the my lord, the first judgment, my lord, 1987, one Supreme Court cases, already I have indicated. Page 5. I'm not repeating, my lord, just indicating. This is with this bunch. This is, my lord, 1987, one Supreme Court cases, 5. My lord, here, let's see, paragraph 9. Then next, my lord, 2010, one Supreme Court cases, 457, paragraph 9. My lord, part cause of action related. From this bunch, lordship will find. Page, my lord, my lord, the compilation, page 9. My lord, this 9. Page 9, paragraph 9. Part cause of action, if arises, lordship can entertain. Then, my lord, page 19 of the compilation.
An identical point.
Yes, but only one thing, when it suits the consign of the everyone, court can intervene. My lord, when, my lord, the technicalities is pitted against substantive right, technicality may not stand. Paragraph 9. I am not, that is why I am not reading, my lord. Page 19 of the compilation, 2013, one Supreme Court cases, 353. Paragraph maintainability. At the same time, lordship was kind enough to indicate today lordship will hear this matter.
Point you have already given. What more judgment you are doing?
My lord, then I'm coming, my lord. Then I'm coming.
Please don't multiply the judgments.
True. I'm coming, my lord. Only one judgment, lordship kindly see. That is, lordship will find 2024 SCC online. 2024 SCC online.
Yes.
Supreme Court 1695. Lordship got it. Lordship got it. Paragraph 34, 35, 40, 45. May I read at least one paragraph, my lord, subject to the leave of this honorable court?
This you have given to us.
No, my lord, not. This was not.
Rohimali was given to us.
Rohimali. My lord, here it is relating to, my lord, the declaring the citizenship. On that particular date, there was no scope. Yes. Kindly see from that bunch. Kindly see from that bench. Paragraph 34, 35, 34, 35. That is page 236 of our compilation. Citizenship have to work on it.
Citizenship, what is required?
However, the question that does section 9 of the Act empower the executive?
So that we have on the Citizenship Act.
Yes, I'm showing.
Section 9 of Citizenship
Of the Foreigners Act 1946 said
Section 9 burden of
burden of proof, since it is burden of 106 of the Evidence Act, because it is my personal knowledge. And the opportunity to be given to satisfy that particular score, Lordship was kind enough, page 34, just we suspect you being a foreigner, and then rest EG basis section 9. Let us contextualize this to the facts at the hand. But here, Honorable Supreme Court deprecated this procedure to pick up certain person and direct him, my lord, to show that you have to discharge this particular burden in terms of section 9. Court was kind enough to deprecate it. Para 35, 36, 30, 34, 35, 40, 45. Then at the end, my lord, declared citizenship. My lord, page 246, paragraph 246. This is very recent judgment. 55. The court has found that the inference drawn by the tribunal do not falsify the appellant's claim. In view of the detailed analysis, the discrepancy in the material produced by the appellant can be termed minor. The same are not sufficient to lead the tribunal to doubt and disbelieve the appellant and the version put forth by him. Thus, we are not inclined to remand the matter to the tribunal for another round of consideration, putting an authoritative judgment declaring, my lord, the citizenship. Only one judgment my lord, court ought not to, my lord, say no. Kindly hear page 95, this is the judgment passed by this honorable court. One sitting with Honorable Justice Ishita Matre. Undue haste, page 95. One judgment, my lord, I am begging. Page 95.
also there in the
Yes, my lord, because on that date, lordship prevented me, my lord, not to make any sub paragraph, my lord, 14. 14. Last two line, my lord, such unusual haste on the part of respondent authority maligns and vitiate their action. So, my lord, undue haste is on the face of record. And lordship, lord, keeping in the mind the provision of section 3 of the Citizenship Act, my lord, acquisition of citizenship is, my lord, so far my case is concerned. My lord, one is, my lord, the constitutional provision. Constitution says, Article 11, in the event it is not covered by the Constitution, in that case, my lord, statutory provisions are there. That is section 3 of the, my lord, the Citizenship Act 1955, which, my lord, if this honorable court kindly permit me, I can read, my lord, section 3. And this is, my lord, is feat case. My lord, two provisions are there. My lord, one provision is constitutional provision. My lord, number of articles are there to determine, my lord, the citizenship issue. And my lord, after that, Article 11 said, my lord, in the event it is not covered by the Constitution, my lord, one is permitted to come within the ambit and four corner of section 11, Article 11. And Article 11 says statute to be, my lord, formulated for the purpose of citizenship. Now, my lord, 1955 Act is Citizenship Act. Section 3 is applicable so far myself is concerned. Section 3 is applicable so far myself is concerned.
What is section?
3, my lord, I am reading. This is one book, my lord, kindly see. Citizenship Act. Citizenship by birth. Except as provided in subsection 2, every person born in India, so and so, my lord, 1950, but before the 1st day of July 1987. On or after the 1st day of July 1987, but before the commencement of the Citizenship Act 2003, and either of whose parent is a citizen of India at the time of birth. And my lord, I am reading, my lord, 2, 3.
We have taken your book. Don't complain again.
But this is my book possible.
My lord is taking me at this, my lord. This is, my lord, very embarrassing for me. Very embarrassing, my lord. Then I will recuse from this matter. My lord, understanding, my lord, no.
Mr. Chakraborty said that.
No, my lord, I am not in this habit. My lord, I am recusing from the matter here.
Why you are
Feel that I am instigating my case against my lord, my lord. I am the last two, my lord.
Listen our words what we say.
But I apologize.
Instead of losing your nerve, listen to what we say. We had asked, we had said that on that day, it is submission.
I am not supposed to record each and every submission, but my lord, that does not mean that I have instigated. That was the last thing I did.
I don't think that was the implication.
My lord, because my lord is saying that I have taken, my lord has just.
That wasn't a right.
except as provided in subsection 3, every person born in India on or after 26th day of January 1950, but before the 1st day of July 1987, on or after 1st day of July 1987, but before the commencement of the Citizenship Act 2003, and either of whose parents is a citizen of India at the time of his birth, on or after the commencement of the Citizenship Act 2003, both of his parents are citizen of India. So, my lord, section 3, my lord, in support of mine, my lord, my parents are citizen of India. They are in possession of land. They are in possession of all identity cards, on the basis of which
How do you prove your citizenship?
well, we have
Aadhaar card, PAN card are not documents to prove your citizenship.
True.
What
True.
is the other option left? That is your birth certificate.
True.
Birth certificate registration act came when 1969. Correct us if we are wrong.
69.
So, if it is said that in many judgments, if you can produce the birth certificate, that may be construed as an evidence towards your citizenship.
True.
Today, everybody is proceeding on the basis of Aadhaar, PAN, etc., etc.
True.
On the basis of that, your citizenship cannot be established.
My lord,
You may argue, it's a conglomeration of the documents, you may argue.
True, my
But the thing is that does not confer citizenship absolutely upon.
True, my lord. My lord, we are the voter of my lord particular constituency
That we have stated
and
in your-
representation of people act. If lordship kindly see, only my lord the citizen can my lord vote, exercise their franchise. My lord, that being the situation. Now, my lord, the voter I card, my lord, I'm ordinary resident of a particular area. My lord, must be included in that particular segment. That is, my lord. And even very recently, my lord, while deleting the name of some citizen from the voter list of Bihar, Honorable Supreme Court was kind enough.
Other queries, what you are showing till.
I'm sure. My lord, here, Representation of People Act says,
Why you are going to representation of
because I am a voter of a particular constituency, that Muraroi Paikar.
that is your
Yes, my lord, my constituency.
no, this person, the person is a voter.
Voter.
And as per
As per Bill Act 1950, Section 20. Meaning of ordinarily resident. Meaning of ordinarily resident. 20. Section 20. Now, my lord,
foreigner sector, no?
may I hand over it, my lord? May I hand over? I'll take back it. And my lord, their land record, which we have enclosed in our reply, lordship will, my lord, look into.
About land records, we
Yes, yes, I have indicated. Only two things. But Supreme Court was kind enough to direct to dispose of this matter immediately. At the same time, citizenship question is required to be adjudicated by this honorable court, not only in this case, so far the other similar cases are concerned. That is the order which I handed over before this honorable court. What is more, my lord, on dated 2/5/2025, the MHA himself formulated regulation. That regulation was not complied, so far this case is concerned. Now, my lord, order to rule 2.
But their answer is yourself confess
So,
that
my
you
lord,
are a Bangladeshi. Instead of retorting plus
yes, my lord.
understand their
Yes, my lord. Yes, my lord.
that when you were interrogated and the particulars were filled up as per the
Yes, my lord.
norma,
Yes, my
you
lord.
have confessed. So once you confess, question of further inquiry does not arise.
Yes, my lord.
This is their point.
My lord, this is before a foolish authority. Confession made before the foolish authority is not an evidentiary, unacceptable. My lord, what is more, order to rule 2. My learned senior, my lord, Mr. Chakraborty, my lord, referred the 226 rules, where my lord 53 is there. 53 I am reading, my lord. Lordship knows, my lord, I need not read. My lord, as far as practicable, that particular word has been used there. 7 except as provided by the rules and subject thereto the provision of the Code of Civil Procedure in regard to suit shall be followed as far as it can be made applicable. In all proceedings of Article 226, nothing in these rules shall be deemed to limit or otherwise affect the inherent power of this court to make such order as may be necessary for the ends of justice and to prevent abuse of the process of the court. My lord, what is more, my lord? Section 141 of the Civil Procedure Code. Let me hand over. 141 of the Civil Procedure Code, where in explanation in this section, the expression proceeding includes proceedings under Order 9, but does not include any proceedings under Article 226 of the Constitution, that is, my lord, the Civil Procedure Code. Now, considering all these aspects, considering the plight of this, my lord, the helpless people, and considering, my lord, the one lady who is in advanced pregnancy in, my lord, the Bangladesh jail, my lord, lordship may kindly be, my lord, look into the issue, and my lord, and considering the judgment which I have relied upon, I have supplied them my lord, the all details, which judgment and which paragraph I am relied upon. My lord, this is my humble submission before this.
Yes, Mr. Chair.
Lord, on the last occasion, kindly come once in the list to your lordship's order. Dated 9 September 2025. I am perfectly all right. But what my Mr. Chakraborty, the other what Mr. Chakraborty, what Mr. Chakraborty was trying to.
In many of cases, when we were taking service, that we will be granted by Mr. Chok.
I have done that. I have given the name.
Don't have any sort
No, only thing I am surprised to see and bring it to your lordship's notice once in the list. Why I am agitated now? Kindly come once in the list to your lordship's own order. 9th September. What I was doing and what is the order recorded and what Mr. Chakraborty was to reply. Instead of doing that, he is going into the merits of the case time and again. Kindly come to the last page, page 4 of your lordship's order, 9th September. I was taking from the day one the question of maintainability. And 9th September order clearly demonstrates, records that I took the plea and he was to give reply. 9th September order, page 4, internal page 4, last page. My lords have got it. However, to conclude his argument on this issue of maintainability, he prays for his accommodation. He prayed for accommodation. Therefore, that issue was kept alive. Now comes the other question which fell from my lords in the last occasion. 11th, the first order which was obtained by Mr. Chakraborty of 11th July 2025.
He made an observation.
Yes, this is obtained by practicing fraud upon the court. Because on that date, what happened? Three things. One is they were detained at Delhi. They were interrogated at Delhi. They are deported from Delhi via Indo-Bangladesh border to Guwahati. Therefore, this was not brought to your lordship's notice. This was not brought to your lordship's notice that two petitions are pending before Delhi High Court. One is habeas corpus, the other is. Yes. Therefore, this order is a nullity because has been obtained on practicing fraud upon the court. Number two. Number three, that when your lordships are adjudicating the question and issue of a habeas corpus petition, when your lordships are adjudicating a habeas corpus petition, now your lordships are aware with your lordships past experience that cases are decided on facts. Pavan Kumar Dubey's case, 1976 Supreme Court, down the line to Narmada Bachau's case, consistent view of the Supreme Court is that if there is slightest presumption of fact, there shall be sea of difference. Therefore, there must be, even if there is a ratio, it is not binding under Article 141 if there is a slightest difference of fact. Not to speak of Article 142. 141 also restricts on the question of fact. What is the fact? That they are detained in Delhi. They are interrogated in Delhi. Respondents are at Delhi. Their case made out is at Delhi. Representation is for consideration at Delhi. And in the event it is not considered a threat or otherwise something was said that in the event it is not considered, we shall move to Delhi High Court. So, what is the subsisting cause of action to maintain a habeas corpus petition in Calcutta High Court? Third,
The last slide we did.
when the last representation they have made in the writ petition to Delhi staff officer, pointing out that in the event that staff officer does not take any decision, they shall move to Delhi High Court. Therefore, consistent view of Delhi High Court. Respondents are of Delhi. Now, my lords have been pleased to ask him that we have taken the defense in this particular case that when they have admitted that they are Bangladeshis, that is where the subsistence list pending. More so when after deportation on 26 June 2025, there is no whisper from either from the petitioners or from the Bangladeshi High Commission that these persons are not Bangladeshi citizens. They should be given back or remitted back or deported back to West India. No whisper since 26 June. Nothing pleaded. No supplementary affidavit. Absolutely misconceived petition.
That they referred to such a that 27 order of deportation that was referred to in the petition, subject to be corrected.
No. What they have desperately tried is to improve by filing reply.
Just I may be wrong.
Nothing about Delhi High Court, my lord. Nothing about two petitions.
Yes, that you have said that Delhi High Court, which was moved, was not referred to in the petition. When it was pointed out, they said we will withdraw the petition.
Yes.
Now, when they withdrew the petition, they did not take any permission to
leave. They did not take any leave. And even if a leave is obtained, I have submitted, it cannot have a retrospective effect. Leave is always prospective for future litigation. That is order 2 rule 2, order 2 rule 3, order 2 rule sub rule 3. And that cannot have revived.
Extension is if granted.
Yes.
That would have been prospective in nature, but by that time the deportation order has been passed.
Passed and leave, even if granted, that shall not revive this habeas corpus petition before your lordship. Already pending by that time. Now, section 41 of the Specific Relief Act, which is the first codified law of 1947, which deals with the question of relief, injunction or otherwise. There, section 41 says, if the conduct is bad, no relief at all. That is 41, last portion, conduct of the parties. Section 41 also says, section 41H, if there is an alternative remedy, any other remedy, no question of any relief or injunction. It has rightly fallen from my lords that there is no annexure of birth certificate. That is prima facie a document of citizenship under the other relevant statutes like the Passport Act and other acts. No specific case is made out in the writ petition about their citizenship. Simpliciter, a desperate attempt has been made to make out a case of habeas corpus illegal detention. There is no prior mirrored in the writ petition to declare that they are citizens of India. They cannot be detained in Delhi. Nothing, no declaration prayer, no citizenship prayer.
Even if declared, burden will be upon them.
Exactly, 61 Supreme Court, full bench judgment I have referred to.
That burden would be
Upon them to prove. Section 9 of the Foreigners Act, and that too the Supreme Court in the full bench said, the question of deciding citizenship is a burden, not only a burden, it's a question of disputed questions. Lot of evidence has to be laid. Nothing is pleaded. 61 Supreme Court, no answer to the 61 Supreme Court has been advanced to your lawsuits. Yes, that is about territorial jurisdiction. I'm coming to that. 61 Supreme Court has two parts. One is deportation, Foreigners Act, and the other is citizenship. Both the points are against the petitioners.
Paragraph 6.
No, I have referring to
Paragraph 4.
Yes, paragraph 4 onwards. 4 is about the Foreigners Act and deportation questions, and Citizenship Act is para 3, illustrates section 9 of the Citizenship Act, and then comes para 5, dispute that the respondent was a foreigner. Now that apart, your lawsuits are aware that if a foreigner remains in a country without a valid visa, he is liable to be criminally prosecuted. He cannot remain a single day. Kindly also come to para 7 of the judgment, full bench judgment. Passport entry into India, Passport Entry into India Act, Foreigners Act, even if it is repealed, the new act completely prohibits overstaying in a country without a valid visa. And that about passport. And if he continues after expiry of the visa, he is liable to be criminally prosecuted. Because I was submitting before your lawsuit on the last occasion, it's a question of sovereignty, national security, and integrity of the country. In so many words, it has been explained in the Passport Act, the Foreigners Act, and the other acts. Now comes the next question. Para 7 of the 61 Supreme Court full bench also deals with the question whether the respondent is a foreigner is a question of fact on which there is a great deal of dispute, which should require a detailed examination of evidence. Therefore, I was submitting on these three, and therefore your lawsuits are aware. I need not submit anything more that if there is a full bench judgment, that shall have an overriding effect on all other subsequent judgment, even if on this question that is par impurium, because it is oblivion to this act and a statutory provision. If a judgment is delivered in oblivion to a statute or a oblivion to a full bench judgment, it is a judgment subsequently, if it is delivered in oblivion to a statutory provision or in oblivion to a settled law, settled by the full bench apex court, it is par impurium and it is nullity.
This full bench judgment, your contention is that the citizenship issue equals burden of proof upon the person concerned, and second is it is a question of fact for which can be gone into by tendering appropriate.
And that apart, the question of Foreigners Act has also been dealt with. Here in section 4, section 2A of the Foreigners Act.
Suppose this question of, because before in the Foreigners Act there was a provision for tribunal subject to be correct. Now in this case, if there is, we accept your contention. These disputed questions Decide.
You know, pardon, kindly consider the given facts now, as of now, today.
No, that you have argued, we have taken note. We are asking a question to you. There, suppose you are arguing that these are all disputed questions. Citizenship cannot be decided in this fashion.
Yes.
Which will be the forum after this judgment? Which will be
After coming into operation of the Citizenship Amendment Act, whosoever, yes, no, the recent Citizenship Amendment Act, whosoever is claiming citizenship, that has been clarified in respect of persecuted
yes.
Hindus, Buddhists, Christians, and Jains, and Sikhs. They may make an application for citizenship or declaration anyway. And all procedures are laid down in the citizenship rules. Therefore, there is no whisper of prayer, either prayer or amendment in the writ petition, that they are citizens. There should be a declaration that they are the citizens. I firmly believe that had these questions been brought to the notice of the Honorable Supreme Court, this order could not have been passed by the Honorable Supreme Court. Pendency before Delhi High Court and all this.
You could in fact have said considered.
Because that was on mentioning. In respect of another matter, had all these facts been there. Now comes the question of suppression of material facts. If there are suppression of material facts, yes, no question of any relief under equity. Equity is a bar, absolute bar. Then, my lord, admittedly, whether any list is pending before your lordships. Habeas corpus petition, Delhi High Court withdrawn. Firstly, no relief was granted, withdrawn. Then deportation, challenging deportation order, that was subsequently withdrawn. Yes, they have withdrawn it. Delhi High Court, they have moved two writ petitions. One is challenging detention, habeas corpus. The other is deportation.
Deportation they withdrew without any leave to move.
Yes. Now, if any leave is granted.
But they showed us that one line that deportation was not challenged, detention was.
Deportation was challenged.
Specific prayer too. Where is that page?
One by one. Page 55 of our page 55 of our application. When the deportation order was challenged, there was no question subsisting. Page 92 of the opposition. That is your revenue opposition.
Page 92.
Kindly come once in the list, not the continuation. There are page 87. Prayer is B. Prayer is B in Delhi High Court. To take legal action against the FRRO, that is their petition, who ordered to deport the detainee, namely such and such. Therefore, deportation was subject matter of challenge there. Now comes the moot question. Then after the deportation, and the dates are very relevant. when they approached the Delhi High Court to do writ petitions. When they filed the writ petition here, whether subsisting cause of action to maintain a habeas corpus petition. And my lords are aware what is defined in Article 226 habeas corpus, illegal detention. That cause of action is no longer surviving to entertain a habeas corpus petition. Then, my lord, I have submitted and placed the latest view of the Supreme Court of my lord Mr. Deepak Datta, the division bench, about territorial jurisdiction. Yes. The question of the protection under Article 226(2) of part cause of action will not apply also here, because the entire fact made out by the petitioners there are of Delhi High Court's cause of action. Petition is of cause of action of Delhi High Court. 226(2) part of cause of action was not subsisting at Delhi. There cannot be a splitting of cause of action, multiplicity of cause of action for a particular benefit to a particular person. The cause of action is one and final, and that has been availed at Delhi. No relief was granted. Conveniently, it is withdrawn. And therefore, the question of deportation which has taken place, it was withdrawn. This is doctrine of issue estoppel applies against them. Even they cannot challenge now the order of deportation. Issue estoppel, and if I may say so, the interpretation of section 11, explanation 4 of the Civil Procedure Code, in broadly if it is applied, a constructive res judicata, a question ought to have been raised but not raised. Issue estoppel and constructive res. Then I am again submitting, Lord, that if they are to challenge the deportation and if there is any subsisting list or cause of action pending or surviving, they are to move it before the learned single judge of this court as per determination. Or Delhi High Court or Guwahati High Court. Even if it is made here, we shall take the same plea, the territorial jurisdiction. If it is filed at Guwahati High Court, they are deported there through Indo-Bangladesh border. Yes, Guwahati High Court is maintainable, or at Delhi. And your losses are aware, the Supreme Court, in case Rajasthan's case, 1998, volume 1, SCC, page 1, has categorically stated that the honorable judges are given the power to determine cases only on the basis of determination by the Honorable Chief Justice, who is the head of the roster. Beyond that, if any order is passed, that shall be a nullity. I had the privilege to argue before the Honorable Acting Chief, then Honorable Acting Chief Justice Bhaskar Bhattacharya, the division bench. matter regarding the determination before the then Honorable Acting Chief Justice Bhaskar Bhattacharya speaking for the division bench. 2010 Volume 2 Calcutta High Court notes. Exactly page I am not being able to remember, but I have argued that matter. There the question came up that if anything is decided which does not fall within the specific determination given by the Honorable Chief Justice, it is not only the order passes nullity, it comes within the scope of return of plaint to the appropriate forum. That is, yes, but that is habeas corpus, you will understand where to send it. Yes, the deportation is not challenged. And finally, my learned friend has said about section 141 of the Civil Procedure Code. May not your lordships are aware, I need not trouble your lordship on this question. The rules framed by the Chartered High Court shall prevail over Civil Procedure Code. And Rule 53 framed by your lordships clearly states the principle of Civil Procedure Code shall apply in a proceeding under 226. There are a number of judgments, I did not bring it, of this court and the Supreme Court, that Order 2, Rule 3 shall apply in its proceedings. So, my lord, one of my matters is called out. Mr. Tiwari will give 3 judgments only. Kindly allow me to go. No, he will just give 3 more judgments. One of matters is called out. Kindly allow me to go.
That interrogation report, what you said?
Interrogation report or deportation again goes back to the moot question.
If we decide maintainability, because we tomorrow you have substantively argued, we have some questions on the basis of the interrogation, so that we can Mr. Trivedi and Mr. Tiwari can give them. There is no requirement. On merit of the matter, the question of because you have we have gone through, your contention is question of inquiry does not occur since there has been a confession. In view thereof, question of routing it to the state of West Bengal was not required at all in terms of the second May circular.
That apart.
Please, Mr. Chakraborty.
No, when the judgment of the Supreme Court, full bench judgment of the Supreme Court is absolutely clear on this question. I have said whosoever has a right to remain in India, it is to be interpreted on the Foreigners Act, into India by the Passports Act. Have they been able to, as rightly fallen from your lordships, where is the birth certificates? Claiming prima facie evidence that they are citizens. Where is the averment in the writ petition? They are citizens. Can they? They have no prayer. Their prayer is simpliciter habeas corpus, illegal detention. The power to detain a person whosoever is found to be illegally occupying the land of India, the sovereign land of India, is unfettered to the government of India.
Why did you issue that circular of 2nd?
That 2nd May circular, even if the time gap is given, does it preclude that in no case?
No, it does not preclude. Then you have to mention the emergent situation which was there.
Emergent situation, it has 3 parts. One is the detention. The other is taking them to the committee room.
Of national threat to the country.
Yes.
That is not the stand of the authorities.
That
were stated, Mr. Chakraborty, that if we keep that person here, it will be a danger to the society.
A particular person's name is not to be mentioned at all. Kindly come.
Opposition, paragraph.
Our opposition, page 9.
G.
Page 9.
Yes. G. At the top, after skipping over one line, page 9.
That is no longer available because you have deported.
Milord, anybody, kindly appreciate anybody who is claiming subsistence right under the constitution. Your lordships are adjudicating a matter under the constitutional code. So what is the constitutional court's right? Adjudication of violation of fundamental rights, mainly, basically, and any other legal right. Now, if any other legal right is not established in the writ petition, can the court extend its jurisdiction and decide that list? And what the writ petitioner, why I am asking a question to myself, why the writ petitioners are silent about so many months, since 26 June 2025 till today, the whereabouts of those persons, whether they are taking steps to bring them back to India, they are negotiating through the embassies, they are not in Bangladeshi citizens, no government at all. Presumption and estoppel also applies now. Until date, we have not received any communication from Bangladesh Embassy or High Commission that these people are not our citizens, they are Indian citizens, they are been illegally deported, nothing, no affidavit, nothing. And except the writ petition and a desperate attempt to improve the writ petition by filing a reply, including so many things which are not part of the writ petition. My lord, kindly appreciate the fact of this case. Whether on a given situation your lordships will at all entertain on all the points I have advanced. Whether habeas corpus petition's lease is pending before your lordship at all today.
Submission on merit is those becomes irrelevant since the maintainability is
Exactly. I get full trust. Because actually your lordships have also experience, I have also experience. If maintainability goes to the root of the matter, whether court is given the jurisdiction for continuation of the proceeding at all, if it is otherwise barred under law,
Mr. Chakraborty, whenever maintainability we have taken note of your submission on the affidavit, if that can be apprised by Mr.
yes, Tiwari. One of my matters is called out, I mean, I leave.
So on merits we will ask those questions and we will finally decide. If we hold that it is maintainable, we will adjudicate the arguments advanced on merits, and if it is not maintainable, then the entire.
And Mr. Tiwari will also hand over some judgments also regarding, in addition to what I have said about maintainability. Maintainability. Yes. May I have your lordship?
Yes, Mr. Chakraborty. All erased.
All erased.
What's the problem?
When we are students of mind, all passion spent.
Kindly takes my application, my lord. That is, my lord, can 1 of 2025. We have what we have stated. Lord, I'm not repeating the same thing, Lord, which Mr.
Go to the on merits with the documents, sir, please tell us.
Yes. On merit, my lord, I will be submitting, my lord, few things. First of all, my lord, kindly take, my lord, one document. That is, my lord, page 61 of my application. Page 60, my lord, sorry.
Page
60. Now you will also find, my lord, this is the Aadhaar card of one Karishma Khatun. Now this Karishma Khatun, my lord, Delhi High Court. Now this Karishma is claims to be the daughter of one Bholu Sheikh. Now kindly turn page 60. You will also find the address is daughter of Bholu Sheikh. Juggi number such and such. Bholu Sheikh. BHOLU. Bholu Sheikh. Now who is the petitioner before your lordship? Bholu Sheikh. Lead petitioner is Lord Bhodu Sheikh. BHODU. Bhodu Sheikh. And Lord, page 20 of the writ petition, Lord, you would also find the affidavit portion. Bhodu Sheikh.
Not Bholu.
Bholu, not Bholu. So, Lord, Karishma is the daughter of one Bhodu Sheikh, not Bhodu Sheikh. As per document, Lord, Annex Act, page 60. Now, Lord, next document, page 61. You also would find, Lord, this is the Aadhaar of Sonali Khatun. Date of birth is 1/1/2000. Now, my lord, address you will also would find care of Danish Sheikh, Paikar, district Birbhum, West Bengal. Now, Sonali is care of Danish Sheikh. She is not the daughter of Danish Sheikh. She is not the husband of wife of Danish Sheikh. Nothing has been mentioned. Care of Danish Sheikh. Now, next page. Come to page 62.
Father's name Danish. Father's name
Interesting. Kindly down page 62.
Page 62 of.
Of my application.
Can.
Can. Well, I'm just referring the can. It will be easier for me also. Now, it is more interesting, Lord. Can you see? The income. Lord, page 62. Sonali Khatun, father's name Danish Sheikh. Which one is correct? Lord, I'm asking the question to myself.
No, page 62 and page 91 you said.
Page 6, I am referring to 3 pages, 60, 61 and 62 of my application.
99 in your opposition is the income tax card.
Yes.
Same document. Same document is in page.
Yes. But kindly take some of my application, it will be easier for you also. Yes, yes, yes. 3 documents, that is 60, 61, 62. 60 I am showing just to show the Korishma Khatun is the daughter of Bholu Sheikh. The petitioner before your lordship is a Bholu Sheikh. Page 61, my lord, Sonali Khatun, Aadhaar card, date of birth 1st January 2000, care of Danish Sheikh. Now, next page, page 62, PAN card, that is Sonali Khatun, father's name Danish Sheikh. So, which document is correct? Now, my lord, your lordship knows, my lord, the Aadhaar Act. Aadhaar Act, my lord, Aadhaar targeted delivery of financial and other. Yes, section 9 of the Aadhaar Act, my lord, clearly says, my lord, your lordship, my lord, kindly have a look at the Aadhaar Act once.
No, we are not disputing.
Section 9 says,
Aadhaar Act is for identity.
Aadhaar number not evidence of citizenship or domicile, etc. The Aadhaar number and or authentication thereof shall by itself confer any right to be the proof of citizenship or domicile in respect of the Aadhaar number holders. Now, my lord, kindly consider one thing. My learned friend has annexed so many documents. But what is the birth certificate? My lord, your lordship knows, my lord, as per the Passport Act, if any person, my lord, born, my lord, after 26th of January 1989, his or her passport shall not be issued until unless he produces the passport, birth certificate. 26th January 1989.
Born after the said date.
Yes. Well, kindly have a look at the Passport Act once. Yes. So, my lord, he has annexed, my lord, so many documents. So, where is the birth certificate of Sonali Khatun? Where is the birth certificate of Danish Sheikh? Where is the birth certificate of minor children? The minor children, my lord, must have produced the birth certificate. Where is the birth certificate? There is no birth certificate at all. Now, my lord, kindly consider today, my lord, so far as, my lord, order of deportation was made, my lord, prior to that, my lord, I will be just referring to your lordship, my lord, 3 GDs. Hmm. 74. My lord, this is, my lord, The General Diary number 52A dated 21st of June 2025 recorded at about 17:43 hours. This General Diary may just place it. At this time, it is recorded that head constable along with the accompanying staff, such and such, along with 3 illegal Bangladeshi, Danish, son of Munna Sheikh, village such and such, post office such and such, have come to the police stations, and situation is such that my SI along with the accompanying staff, while searching for illegal Bangladeshi citizen, reached Bengali Basti, sector 26, Rohini, Delhi at around 3 p.m. with a special informant met and informed, and in a short while the Bangladeshi man is going to come here to meet someone. Head constable along with accompanying staff along with the special informant started waiting for the Bangladeshi man, and at around 3:30 p.m. seeing a person coming towards us, the special informant pointed out that this is a Bangladeshi person who is living illegally in Delhi. When the person was stopped with the help of the accompanying staff and questions, he told that he is a Bangladeshi citizen and his full name and address is Danish, son of Munna Sheikh, village such and such, admits. Now, my lord, after these admissions, now, my lord, next, my lord, if your lordship, my lord, kindly, my learned senior friend has produced, has referred all these documents. Kindly take page 81 once. Page 81, you will also find this is, my lord, request for issuing restriction or deportation order against illegal migrant found in the area of Rohini district. It is issuing by the Office of the Deputy Commissioner of Police, Rohini district. It was written by Additional Deputy Commissioner of Police 1, Rohini district, Delhi. What he is writing, my lord? He is saying that it is to state that during verifications drive, total 6 illegal migrants of Bangladeshi were found to be living illegally in Rohini district, Delhi. In this, inquiry has been conducted and found the following events along with the Bangladeshi. During inquiry, it was found that they did not acquire any Indian identity document and their presence is not required in any criminal case in India, and their details are under. All details have been provided, and thereafter, my lord, these documents were shown to your lordship. That is page 83. The format for requisite particulars of national status verification and all these things.
That must have been.
Yes. That. Now, my lord, after that, your lordship, my lord, kindly turn, my lord, the order of deportation, that is at page, prior to that, my lord, there is a certificate given, page 95. Kindly turn, my lord, page 95 once. The 95 and 96, there are 2 certificates. Page 95, it is certified by the Assistant Commissioner of Police. It's saying, my lord, it is certified that I have personally satisfied myself that Danish, son of such and such, Sonali, such and Sabir Sheikh, son of Danish, and presently resident of such and such, Delhi is a foreigner illegal migrant from Bangladesh. These 2 certificates were issued by the, my lord, Deputy Commissioner of Police. Next, my lord, page 97, the order of deportation. Now, this order of deportation, my lord, it is dated, my lord, 26th of June 2025. My lord, this order of deportation was very much within the knowledge of the writ petitioner, my lord, the Karishma Khatun, who moved the writ petition before the Honorable Delhi High Court. My lord, this was challenged in the subsequent writ petition. In the subsequent writ petition, which was withdrawn on, my lord, 12th of August 2025, that was the subject matter of order of deportation.
That we are.
Yes, that is your lordship would get it, my lord, in my application, page 55. This is the second petition.
And clause B, you are saying?
Yes.
That means that the deportation was.
Deportation order was challenged before the Delhi High Court. So, my lord, this deportation order was challenged before the Delhi High Court, and that was the subject matter of Delhi High Court in the second petition filed by Karishma.
This was withdrawn.
This was withdrawn on 12/8/2025. Order of withdrawal, your lordship would get it, my lord.
Page 58. No, 58 is the first
Page?
Page 58 is the.
Your lordship, page 79. Your lordship, can you turn page 79? Page 79 of my application. Yes, this is the order, my lord. The present petition has been filed under article such and such and such and such in the nature of habeas corpus or any other writ directing the respondents to produce the family members of the petitioners. On instruction, learned counsel for the petitioners seek permission to withdraw the present petition. Permission to withdraw is granted. Next, page 80. Accordingly, present petition is dismissed as withdrawn. So no leave, nothing else, my lord. The order of deportation was challenged. It was withdrawn. Now, kindly consider, my lord, kindly takes, my lord, your lordship's order, first order. That is 11th of July 2025.
That was obtained upon suppressing facts.
Yes. Blood only on the this on 11th of July 2025, my lord, this Bhodu Sheikh had all knowledge. But he did not disclose all these things. And so far as this part is concerned, my lord, my lord, I will be referring one judgment, my lord, regarding suppression.
Answer to questions.
Yes, my lord, I will be answering, my lord, one question. In this order, my lord, your lordship raised certain queries. Now, my lord, what is my yes? Kindly turn, my lord, the opposition. Take the opposition of the respondent number 1 to 4. Additional of affidavit in opposition. Kindly turn, my lord, page 5.
Yes.
Page 5, my lord, I have given all the answers. Page 5, my lord, before dealing with, my lord, paragraph 3, all the answers, my lord, as per, my lord, I am not reading all these things. My lord, all answers, my lord, I have provided. Only, my lord, your lordship also asked for answers regarding, my lord, compliance of Roman 6, Roman 3 of the circular dated 2nd May 2025. I have said if somebody said I am a foreign national, there is no question of ascertaining the fact from the concerned UT or what is the UT? What is the state? They do not belong to any state in India. They do not belong to any state in India.
Answer this question of us. Kindly come to page 8, the last paragraph which you are 8.
Page 8.
What is your verdict? Honorable Court on 11th September, quoted clause 3 and 6, issued by Minister answering.
Answering the respondent state that
it is an admitted position you have relied upon. In your evidence, recognized to be first. Now, second means answer the state report of Delhi shows
that the
provided the address of
Bangladesh did not claim to be Indian citizen. Produce any identity card providing to be the Indian citizen.
Of clause 6 stated that could have come into picture only if detainees had.
Yes, yes. If the detainee had claimed Indians, then compliance of that comes. Otherwise, not.
Now, for that you went upon the interrogation, which is a typed copy of the document bearing the signature. Then why does your FRO say that there was an inquiry, which you just now page 81 of your application? The document which is issued by the certificate which you
Yes.
Your additional deputy commissioner says that we have conducted an inquiry.
Page 85, I annexed the interrogation report.
Yes, so this is the only.
This is the interrogation report. This is my only document.
This, according to you, on the basis of this, we have passed the order.
Yes. On the basis of this, we have passed the order of deportation, number 1. Number order of deportation was challenged by the Delhi High Court. And so far as merit is concerned, I am still now harping on this issue that a person claiming to be a citizen of India, my learned friend has relied upon section 3 of the Citizenship Act. Section 3 of the Citizenship Act says, if I born during this period, birth certificate is must. Kindly have a look at section 3 once. How would I prove? Kindly take page 6 of this book. In subsection 2, every person born in India on or after 26 January 1950 but before the 1st July 1987, let's skip that. Next, on or after 1st day of July 1987 but before the commencement of the Citizenship Amendment Act 2003 either of whose parents is a citizen of India at the time of his birth. Next, on and after the commencement of Citizenship Amendment Act 2003, where both the parents are citizens of India or one of whose parents is a citizen of India and other is not an illegal migrant at the time of his birth, shall be the citizen of India by birth. So, my lord, citizen of India by birth after, my lord, 1st July 1987, and my lord, Citizenship Amendment Act 2003 came into force, my lord, on 1st of January 2004. My lord, during this period, if someone, my lord, born, my lord, birth certificate is must. Birth certificate, and the same would be reflected from the yes on 1/1/2004. Now, my lord, during this period, now, my lord, kindly see the Sonali Khatun. His date of birth is 1/1/2000. 1/1/2000. So, my lord, she is coming within this period. What is the birth certificate? What is the birth certificate? Now, so far as minor children of Sonali and Danish born, my lord, after 2000, my lord, then where is the birth certificate? And my lord, only one, just my lord, only one, two judgment, my lord, I am just referring to your lordship regarding the matrimony point. My lord, this is, my lord, 2006, volume 11 SSC 696. 2006, volume 11 SSC 696. I am just referring the paragraphs, my lord. Regards the mentality of the deportation, I had requested the High Court to grant further opportunity if necessary so arises to file a detailed counter affidavit after preliminary objections were decided. The High Court, in fact, in one of the orders clearly indicated that the preliminary objections were to be decided first, but strangely did not do so. It reserved the judgment and delivered the final judgment after 3 years, and there is a dispute about whether the relevant documents were produced. All these things were there. But I am not saying 3 years case, but the fact is this, Lord, decide it. Next, my lord, judgment, my lord, which I am referring, my lord, that is KD Sharma versus Steel Authority of India Limited. That is, my lord, 2008, volume 12 SSC 481. Milord, this is not in respect of, I'm just pointing out, this is not in respect of 11th July 2025 order passed by your lordships. Milord, my ASG also submitted that they have suppressed all relevant facts. They have committed fraud on court. So this, yes, this is the judgment, my lord, where Supreme Court says, my lord, kindly consider the conduct of a person, my lord, who is approaching the court. My lord, kindly turn the paragraph 36(2), my lord, paragraph 36 to paragraph 52. All these paragraphs deals with, my lord, conduct. (36) to paragraph 52. All these paragraphs, my lord, deals with the conduct. My lord says, my lord, the conduct is such, he should be thrown out.
Yes, Mr. Mayor. Mr.
Trivedi, Mr. Trivedi.
Well, nothing to add, Millard, whatever is, just one factual aspect, Millard, which I think, Millard, the documents we were not privy to as far as the first writ petition is concerned. If my lord kindly sees the annexure to the first writ petition, they only annexed the complaint which they had lodged to Delhi police. It was the second writ petition, which was filed during the pendency of this petition under habeas corpus. In that, they had annexed those documents. So we were not privy to those. My lord will kindly come to the first. My lord will kindly take up the application.
Your opposition.
My lord, not opposition. My lord will kindly take up the can only. Yes, my lord, because if my lord kindly sees, this is the second writ petition. It starts at page 51. This is the second writ petition, where, my lord, in the list of date, my lord will kindly come to page 49. List of dates, my lord will finally see that this is the second writ petition. Page 49, my lord, of, my lord, the can 1.
Both the documents, it bears the date 23rd June.
My lord, no, my lord. What I am, my lord, first, my lord will kindly come to. আমার তিনটে number হয়ে গেছে 19th. It is 19th. My lord, that is 19th June, my lord. My lord, that না ওইটা আমি এক মিনিট বলে নিতে দাও, দাঁড়াও, নাহলে সব গুলিয়ে যাবে। My lord will kindly first take page 28. The writ petition, the first writ petition, it starts. Number হয়ে গেছে। ভুল দিয়েছিলাম। Of June, the Honorable Delhi High Court decided they have been deported. At that point of time, they were deciding this writ petition, the first writ petition. The first writ petition did not have any documents, which all came later in the second writ petition. Now, the second writ petition, my lord, kindly see, starts from page 46. And, my lord, there, my lord, the annexures start from page 57, where, my lord, they have first annexed the order passed by the Delhi High Court. My lord will kindly see. The second writ petition, which starts at page just after the order of the Delhi High Court on 30, my 4476, both.
Documents were not given.
My lord, prior to that. So, my lord, what they are saying, my learned friend was trying to impress very humbly before my lords, that we were already aware.
So this
At
is wrong, Mr. Chopra. First petition, no annexed. My lord, the document which they have enclosed, my lord, I have trying to, my lord, inform this honorable court, my lord, the documents are there. My lord, if it is wrong, my lord, I cannot improve my case in any manner whatsoever.
my lord, index 24.
You said that they had the documents at the time of deportation because the first writ petition.
Yes, yes, my lord, yes, my lord.
First writ petition had only one annexed.
True.
So they did
Now, my
not
lord,
have
only
the
one question, when it is pending before the constitutional court, FRO is, my lord, immediately, my lord, pass the order and deport them immediately.
It's a separate
My lord, they should wait, my lord. It may, my lord. They are illiterate people. They know only, my lord, the LTI.
The submission that you make
Yes, yes, my lord.
seems
Yes,
incorrect.
because, my lord, my lord, the document which are lying there on the basis of that, I am, my lord, only one thing, my lord, what my learned friend, my lord, trying to say, the father's name is Vulusek.
And my lord, FRR was not a party in the writ petition.
Page 36 of their document, new document, affidavit. Here it appears from their inquiry, Shunali, name of.
My lord, I am appearing for Delhi police, but my lord will kindly see page 32. Five. Delhi police.
Page 32.
Yes, my lord, FRRO was not a party there. Page 32 of our, my lord, can 1, my lord, because I am just relying on that, because otherwise, my lord, if my lord kindly comes to first page 24 of my can.
Yes.
My lord, page 24, just at the cost of repetition, my lord. There, my lord, the index of annexures is there, my lord, page 24. There, the last annexure, my lord, the only one annexure is page 13 and 14, which is the complaint to the DCP. Secondly, my lord, the array of parties, my lords have already seen, my lord. FRRO was not a party. So, my lord, the question of them having documents does not and cannot arise, and even Delhi police did not have those documents.
They are aware of it.
And then, my lord, the order dated 30th of June was passed. Subsequently, thereto, the second writ petition was filed that my lord is aware of.
Same thing, my lord, same thing, repeating.
The second writ petition was filed, in which they categorically in the list of dates stated whatever was the chronology of events. And then they filed these documents over there, which is the next one.
No,
And
page 36 of the affidavit state, Shunali, daughter of Bodhushek, not Volushek. Well, they are also trying to mislead this honorable court.
Well, their document, what I will mislead.
Page 36, interrogation report said, Shunali is the daughter of Bodhushek. So, Volushek, Bodhushek, my lord, kindly see. Then, my lord, two judgment placed by the, you've got it, page 36 of their affidavit. Volushek and Bodhushek issue. My lord, two judgment relied by my learned senior. One, my lord, 2023, 7 Supreme Court cases, part cause of action issue, paragraph 6. My lord, paragraph 6 says the short question, 2023, 7 SCC, page 791. Learned senior Chakraborty, my lord, has submitted and referred this judgment, my lord. First, my lord, 2023, 7, then I am, my lord, the constitutional bench judgment, I will cite. 7. Here, my lord, paragraph 6, the short question that arises for a decision on this appeal is whether the High Court was justified in returning a finding, at least a part cause of action has arisen within the jurisdiction of this court and premises such a finding to dismiss the application. My lord, in the event no, my lord, part cause of action up there, the petition is destined to suffer. Our humble submission before this honorable court, part of cause of action is here. We are permanent resident. Our family was dependent upon them. And my lord, they are deported from this border. My lord, they have stated Assam border without enclosing and annexing a single scrap of paper before the honorable court. They are trying to withhold their document-based document. The second judgment, document, my lord, ticket, the other things are there, and they have accepted them. The BSF of Bangladesh board. No, my lord, they are taking this particular plea. They have not yet been deported. Deported to Assam border. This is their stand. Lordship was kind enough. Our case is they are deported, my lord, through West Bengal border, because they are found in such a place which is close in proximity to West Bengal border. And they are arrested there. It is not possible for them. They have no money, nothing of this kind.
and cannot come from Assam border to, my lord, this particular place, which is in and around, my lord, West Bengal. My lord, no document they have submitted. The other question is, my lord, the Constitutional Court judgment. Here, my lord, paragraph 7, the question whether the respondent is a foreigner is a question of fact. And there is a great deal of dispute, yes, my lord, which would require a detailed examination of evidence. 23rd arrested, 24 arrested, 26 deported. And detailed question, my lord, adjudicated in this fashion. My lord, only one judgment, lordship knows. My lord, just
The Delhi High Court, I have.
No, my lord, it is not within our knowledge. We have very categorically in the first affidavit in reply stated by filing affidavit by the respective person at that point of time they were in Delhi. There had no coordination. Yes, my lord, I'm showing.
Reply.
My lord, the first maintainability question, my lord, the affidavit we have filed in our reply. No knowledge between these two relatives, those who are, I am showing.
Affidavit in reply to respondent number 5 or
Yes, the first affidavit.
first affidavit on maintainability.
Yes, my lord, there.
First affidavit on maintainability.
My lord, kindly come, my lord. Kindly come. Lord, kindly come to my lord that affidavit in Bodhu Sheikh case, page 5.
Yes, which paragraph?
My lord, by the the affidavit filed by the Lina Prasad, we have replied to their affidavit in opposition 1 to 4.
That is on 22nd.
No, my lord, that was, my lord, affirmed prior to that, my lord, the outset. That was affirmed, I'm just saying, my lord.
4th of August.
4th of August,
4th of August 2025.
Yeah.
Page 5. Yes, sir. Page 5. Yes, my lord. Second paragraph, on the same date that this Karishma Khatun alias Karishma submitted an informal complaint. Second paragraph onwards. And
on the same date.
My lord,
starting with on the same date.
On the same date. My lord, this is supported by their person. On the same date. Paragraph 7 onwards, my lord, page 4.
Paragraph 5, page 5.
Page 5, it starts from page 4, para 7. My lord, may I read or my lord?
Yes, para 7. What?
7. With respect to the issue raised before the Honorable High Court with regarding the petition filed before the Honorable High Court at Delhi, it is stated here that one Karishma Khatun alias Karishma is the petitioner before the Delhi High Court. The said petition was filed after her sister Shunali Khatun, her husband namely Danish Sheikh and her minor Sabir Sheikh, aged about 8 years, were detained by the police personnel attached to Karjumarg. The said Karishma Khatun alias Karishma approached before the Delhi High Court because her sister...
Is that, why didn't you write that in your second, in this petition?
But this is in this petition in reply, my lord. At that point of time, there was no coordination between Bodhu Sheikh and other daughter Shonali, other daughter Karishma. But in their affidavit, we have stated. I am reading, my lord. That is what I am reading. That owing to the custodial disappearance of her sister Shonali, her husband, namely Danish Sheikh and minor so I am skipping, my lord, 2-3 lines. Then, my lord, turn to next page. However, as an illiterate person with no understanding of legal mechanism or procedural choice, that said Karishma Khatun alias Krishna was entirely dependent on the guidance provided by those around her, including concerned local. Then next paragraph. On the same date, this Karishma Khatun alias Karishma submitted a formal application before the Deputy Commissioner. Then, my lord, skipping, my lord, this paragraph, last 3 lines. Her husband, namely Danish Sheikh and minor son Sabir Sheikh, aged about 8 years, can be brought back to India. And afterwards, the deportation news prompted Karishma Khatun and Karishma to withdraw the matter being number so and so. It is pertinent to mention here that in month of April 2025, Karishma...
Giving our answer. You did not disclose about Delhi High Court.
At that point of time, this was beyond our knowledge. And my lord, Karishma at that point of time was in Delhi, trying hard to find her relative, the sister. Then after a compulsion, he returned to his native place. That we have, my lord, kindly see, 2 are separate affidavit we have enclosed here with. That is page 34-35 and Karishma's affidavit, page 38-39. Entire story we have narrated. the fact remains. My lord, this one, my lord, only one thing, my lord, only one thing. The second aspect, my lord, my learned senior friend, my lord, they are, my lord, agitating no birth certificate. In the second matter, birth certificates are available. Where? Second matter, this Amir Khan matter, 51. Yes, my lord. And my lord, it may be every possibility that 50, the minor son birth certificate is lying with the mother. My lord, since that communication, no communication is there, as a result of which we are not in a position to furnish the document. Only one judgment of page, my lord, 2930 of the second writ application 51. Amir Khan matter. Where my lord, Sweetie Bibi and his minor sons and daughter, those who are reading in the Delhi school, are presently in the Bangladesh jail, my lord. That being the situation. Without page 2930, without considering Juvenile Justice Act. And my lord, just I am referring, my lord, judicial hour is over. My lord, only my lord, the judgment of Justice Shotobrata Sinha and Markandeo Katju, Honorable Justice, page 42 of my lord, bunch of document, where very categorically stated, my lord, I am just reading. I know, my lord, there is another doctrine which cannot also be lost sight of. The court would not ordinarily permit a party to page 50 of the bunch of document, my lord, paragraph 18. You've got it? Here, my lord, but where the paragraph 18, where one proceeding has been terminated without determination of the lease, can it be said the disputant shall be without a remedy? And then again, my lord, para 22, I am not reading it. If that is removed, my lord, court will entertain. So far the other writs are concerned. In habeas corpus, my lord, more flexibilities are there. My lord, no res judicata, nothing of this. This is my humble submission.
Yes. No, but so far as the state is concerned, only Milord,
What you have
Milord, that is my submission is so far as state is concerned, is limited. But the state and central, Milord, this federal structure, Milord, state, when state Milord has made an inquiry upon Milord receiving a complaint or missing diary, whatever it, but it is the duty to respond something. But here, my lord, nothing till today. And my lord, so far as the my lord, the Aadhaar card, my learned senior friend, my lord, Mr. Chakraborty has Aadhaar card. Your lordship knows it, my lord, very recently, my lord, it had been in Joseph. Regarding my lord, the actually certifications of Aadhaar card that has been discussed, and my lord, this directed the commission to last page, reverse page, last short issue. If Aadhaar card is accepted for the casting of vote, the franchise right of a citizen. But if that is so, Honorable Supreme Court has categorically stated, Justice Surya Kanta and Justice Joymala Bakshi, Lordship, kindly see, Election Commission shall issue instructions by tomorrow. They have not left the commission, Central Commission. That Aadhaar card should be accepted along with other documents.
Identity. It's a proof of identity.
Yes, Lord.
Identity for, but what is the subject matter before the Honorable Supreme Court? But I'm putting question to myself. No, identity for casting the vote. For casting the vote. The casting the vote is a right, franchise right of a citizen.
It will come after you establish your citizenship.
Your lordship, kindly consider that. Kindly consider that. Kindly consider, I'm not, so far as our email is concerned, page 81, kindly see, we have sent all after the inquiry. But till today, no response. Is it the duty? And what is their submission? They have, দাঁড়াও ভাই, আমি তোমাদের সঙ্গে বলিনি একটা কথা, চুপচাপ বসেছিলাম।
আমি কিছু বলছি না।
But what is it the duty of the authority to take and to deport? And taking your lordship knows there is no evidential value in the under the evidence.
Unitary state.
It is only for the to
Wishing lordships a very happy puja vacation. My lord, because if
Tomorrow you will
my
not
lord,
come.
I will come, my lord, but I may not have any matters before my lord, my lord. Tomorrow, my lord. I will be there till Friday. my lord.
26 fix.
As a matter of abandoned cause. My lord, I'm always at my lord's beck and call.
On virtual mode.
No, no. Physical. আমি কোথাও যাচ্ছি না।
Citizenship লাগবে?
কোথায়